Thank you. We'll proceed to questions and begin with Senator Shoebridge.
Thanks, Chair. I've got some questions about the arrival control determination order and the impact on Iranian visas. Who's best to handle that?
Yep, Ms Sharp and Mr Whitlock can do that, Senator.
Cool. So on, I think it was the 26th of March, the Minister froze all tourist visas for Iranian nationals. How many people did that impact?
Senator, I think Ms Goodchild will have the figures. It was in the order of about 6,000. But sorry, Senator, can you repeat the question? I didn't quite hear you.
How many people from Iran were impacted by the arrival control determination order of the 26th of March that froze their tourist visas?
Thank you, Senator. So, Tiali Goodchild, First Assistant Secretary, Skilled Temporary and Capability Visas Division. Ms Sharp was correct. As a result, there was about 6,634 visas impacted by that initially.
When you say initially, has the number grown or fallen since then?
No, it hasn't grown or fallen. That was the number impacted.
And the order is in place for 6 months, is that right?
That's correct.
How many of those visas will lapse within the 6-month period?
I don't have that data on me at the moment, Senator. I'd have to take that on notice.
What's happening to tourist visas from people with Iranian travel documents, applications that are happening now? Are they still being processed?
That's correct. They are still being processed.
But then if they're protests and there's a determination to grant them, they're immediately cancelled because of the order.
They won't be granted during that time, Senator, but they are able to apply for a permitted travel certificate. So there are exemptions to the travel determination that they can apply for.
So what's the process? If someone wishes, they would have previously got a tourist visa, do they apply for a tourist visa and at the same time apply for a permit?
Senator, they would apply for the visitor visa. If that's granted, then they would be affected by the arrival control determination. They can then seek a permitted travel certificate, and if that's granted, they can then travel to Australia.
All right. How many permitted travel certificates have been granted since the order was put in place?
So since the order was put into place, we have had 480 permitted travel certificates issued.
All right. And how many people, since the order was placed, have had a visa granted and sought but been refused a permit?
I just have to check if I have that data on me, Senator. I don't think I've got that exact data on me, Senator, right now. I'd have to actually take that one on notice as well.
And you said 480 of permits have been granted. How many have been refused?
There has been 164 declined.
And how many have been lodged and awaiting?
So in total, we've had 752 requests received. Of that, though, some of them were exempt from the determination, so there was 44 of them that were exempt in the first place, so they didn't require a travel certificate.
And can you advise how many tourist visas have been granted since the arrival control determination order has been put in place in relation to people with Iranian travel documents?
I don't have that data on me at the moment, Senator.
All right. Well, could you get that on notice together with... so if someone's had a visa and then the permit has been, the permit request has been rejected, what happens to their... That means their visa is then invalid? What's the effect of that?
No, Senator. Their visa is
frozen.
Frozen, and if it has an expiry date that is after the September date when the arrival control determination lifts, then the visa will come into effect again.
All right. One of the statements made by the government when the arrival control determination legislation was rushed through and then implemented was that it wouldn't affect humanitarian claims because Iranians who were here on shore could make humanitarian claims. Since the determination has been put in place, how many protection claims have been granted to Iranians?
So I think that, Senator, there's a temporary humanitarian pathway that has been open to Iranians for them to be able to apply for that. So last Friday, a form was placed on our website for people to be able to put forth applications for that are on shore. As of yesterday, no one has submitted a application for that temporary pathway.
Well, that's probably because you only put it online on Friday, is that right?
Yep. I was going to also, though, add, Senator, we have had 9 people come to us, not via that web form pathways, that have expressed interest in being considered for a temporary humanitarian pathway, but we now have a process in place that allows them to go onto the web.
And who is eligible for that temporary pathway?
So obviously anyone that fits the criteria of the temporary humanitarian pathway, so that meets the conditions of that pass health security checks, the normal visa processing.
Is it a separate pathway opened only for Iranians who are onshore, or is it part of a broader category of visa? What's the visa category?
So that is just for Iranians that are onshore, this particular temporary humanitarian pathway.
All right. And was there any publication of this pathway? Has it been? Is there a media release? Is there some documentation I can see that shows it?
Yep, there is information published on our website publicly on the Home Affairs website that talks about that and how people can submit expression of interest for that pathway. I looked at,
and are the details about the criteria for it found on that same?
That's correct. So it's open to Iranians that are in Australia who need to extend their stay due to the conflict but are unable to meet the criteria for any other new visa. So they will be considered for an offer of temporary humanitarian stay.
Right. Is there a cost for processing of that?
No, Senator.
When I looked at the Home Affairs statistics published from February to April of this year, it identified 14 people from Iran who had onshore protection applications granted. I'm assuming, can Mr. Willard, are you able to talk us through that?
That's a different cohort to the one Ms Goodchild's referring to. That's the subclass 866, the protection visa cohort. There are pretty much at all times there's a number of Iranians who will be in that pipeline, and in the normal course of processing you'll see grants to Iranians among that cohort. That's a permanent protection visa. That's based on claims that they would have put forward most likely before this whole thing started, but it's like, if you like, the normal pipeline of permanent protection visas.
But how many protection applications have been put in, and I'm not talking about the temporary option that was opened up on Friday, how many protection applications have been lodged by Iranians who are here onshore since the 26th of March 2026?
I'll take that on notice for that date, Senator.
All right, and I've just for completion, how many have been granted, noting that the data I had is February to April.
Sure.
But I'm asking since March 26.
March 26.
How many Iranians are in Australia on a tourist visa currently?
We have some figures on that.
Senator, there's roughly around about visa holders in Australia, there's about 2,833.
2,000?
833 around.
All right,
that.
and have there been any Iranians onshore whose tourist visa expired between March the 26th and now, who have therefore been put on bridging visas or the like because they're unable to get another substantive visa?
I'd have to take that on notice, Senator, to see.
Well, I assume some of this would have been looked at the time you created this new temporary visa option,
Senator,
You must have been looking at Iranians in that situation.
I'm sure there would have been in that period. We did do a lot of consultation with Iranian community groups in the lead up to and subsequent to the control order being put in place. Part of that was engaging with them and putting up specific information on our website about the sort of things that they could look at if their visa was expiring, and very much encouraging people to make an application. What we have seen with this cohort is there is a high degree of self-agency in terms of people making applications for other visas they might be eligible for. As if you like, the fallback to that is the temporary humanitarian option that Ms Goodchild talked about.
And just finally, so I get an understanding of the nature of this new temporary visa option, how does it differ from the protection that was offered to Ukrainians who were onshore here at the commencement of the conflict, Russia's invasion of Ukraine?
The vehicle is the same visa subclass.
Conditions?
It's a 449.
The conditions and entitlements, are they the same? Access to services, continuity of stay, are they the same?
So they would be different
How so?
in terms of access. I would have to come back to you with the details. Senator.
Different insofar as less?
Yeah, let me come back with the details. I'll take that on notice.
But was there a conscious decision to provide less protections for this cohort from Iran than was provided from the cohort from Ukraine in very similar situations?
I'd make the point that in the crisis situations, there's an initial response, and then subsequently, if the situation remains in place, there's a longer-term response.
And I can see the Chair's agitation, but this is one critical issue that I know will be front and centre in the Iranian community's mind. Is there a pathway to permanency from these temporary visas? Because that has been critical. It's been a lifeline for the Ukrainian community. Is that same lifeline going to be offered to the Iranian community through this visa?
As I said, we're still at a very early stage in terms of the response to this crisis, and that sort of thing will be determined and has been determined.
Well, this visa's in place. Does it have a pathway to permanency?
It was done quite late.
Yeah, so the visa that's on offer at the moment is the 3-year temporary humanitarian stay. As has been the case in previous conflicts, as the conflict's progressed and we've gotten a better handle on, is this a short-term crisis with people able to return, or is this a long-term protracted conflict? We will look at what options need to be put in place thereafter.
So at this stage, it's a 3-year temporary visa that's offered.
Which is the same as the initial offer for the Ukrainians.
And so the pathway to permanence was offered
About 12 months in.
after the conflict.
Well, after the initial period of the conflict, once we could see more clearly the state.
All right.
Affairs.
Thanks.
Thank you, Senator Shoebridge. Senator Whitten.
Thank you, Chair. I've got some questions about some numbers in the budget paper number 1. Do you have access to a copy of that?
I do.
It's specifically table 6.16 on page 240.
Yep.
Now in that table, it's got a heading, Management of Unlawful Non-Citizens. It's a subcomponent of the immigration cost budget line.
Yes.
It's 2.2 billion. How many unlawful non-citizens were removed from the country for that 2.2 billion?
Senator, Mr Thomas will be able to help you with the figure, but it's a opening comment. I'd say that line item is picking up a lot more activities than just our removal function. It would be reflecting our entire immigration compliance function, which has many elements that go beyond just the straight removals, but we'll get you the removals figure.
Senator Michael Thomas, Deputy Secretary, Immigration Compliance. In the 2025-26 financial year, up to the 31st of March.
Sorry, I'm really quite deaf. I'm happy for you to yell. Yeah, sorry.
I'll speak up.
Michael, just lean right in.
So for the financial year, this financial year, 25-26, up until the 31st of March, we removed 2,851 unlawful non-citizens from immigration detention. I will note there will be a large number of unlawful non-citizens that have departed during that time as well, just self-departed, as well as being assisted by the department. So that number I gave you was removals from immigration detention, but the number is much larger because of those self-departures.
Yeah. How many did you have to deport, excluding the self-departures?
So that was that 2,851 number for this financial year.
So
Okay,
they're from an immigration detention centre. There is another cohort where we actively are engaging with them, and the person, they're on a bridging visa E, on a departure pathway. We're engaging with them and they depart. It's not considered a removal because they're not in an immigration detention centre at the point they leave the country, but it very much is a departure because of that investment government's making in encouraging people strongly to leave Australia if they have no right to remain.
So to be clear, that is the number of people you physically remove, not people that hopped on a plane themselves and...
That's correct, Senator. I think the point Ms Sharp was making is that they don't just hop on a plane without a lot of work from that compliance team to encourage them to leave because they no longer have a right to stay. So some people just depart by themselves, but there's also a very significant effort in encouraging people to leave because if we can encourage them to leave rather than removing them, it has a different impact on their future options of coming to Australia. And so, it's that kind of work, persuading people that it is in their interests to leave, which also takes quite a bit of resource.
I get it. I wish the police would encourage me to slow down rather than give me a ticket too, but when you're doing the wrong thing, you're doing the wrong thing. So I'll move on. So can you describe exactly what unlawful non-citizens are and who is included in the cohort? Is it only people that have overstayed, or does it include people due to criminal activity also?
Senator, it primarily consists of people whose visas have expired, so they've become unlawful. It may include people that have had their visas cancelled, but the vast majority will be visa overstayers, as you say.
Do you have a breakdown of that?
I don't, Senator. I do have the last visa that the cohort was on before they became unlawful. I can, but most of the, cohort were on bridging visas prior to them becoming unlawful or other substantive visas.
Could you take on notice to supply a breakdown?
I can, Senator, yes.
Thank you. Can you describe some of the management activities that are undertaken for the 2.2 billion, if that's a big component of it?
Senator, in a broad sense, we do a range of activities to identify unlawful non-citizens, to engage with them and to put them on a status resolution pathway. That might be encouraging them to apply for a substantive visa where they're eligible to do so. It might be to depart, as the Secretary said, or it could be locating and detaining them for the purpose of removal. So there is a large range of activities that we undertake across a number of different work streams to identify this cohort, engage with them and ensure that they are on the right pathway, whether that be heading towards a different substantive visa or departure or removal.
That funding line item would also include the budget that's gone into managing the cohort affected by the NZYQ decision, who are people who we cannot remove, but we have invested substantial effort in managing in the community as safely as we can. And it would include our work on migrant worker exploitation as well.
Okay. Do you have a breakdown of those numbers?
We can take on notice.
Take on notice, yeah. So did you say some of the people that have gone to Nauru?
The costs of, I might need the CFO to confirm, but certainly, we will check whether or not the payments to Nauru are included in that $2.186 billion figure.
Yeah, I mean, it's a massive number. There's obviously a lot of things. It'd be good to see a breakdown of where that money is actually going. Thank you. I note the line item is falling to 1.6 billion over the forward estimates. For the past 3 years, are you able to provide the numbers of the people that this line item has related to?
Senator, I think we would need to take it on notice and
Yep.
to be able to do that, because, as I said, my suspicion is that while the line item is titled Management of Unlawful Non-Citizens, it's actually picking up a broader range of work we're doing in our immigration compliance function.
Andrew Harvey here, Chief Finance Officer. I mean, all I can really add is we can answer questions more precisely on our own department's portfolio budget statement. The Blue Book's pulled together by the Department of Finance and Treasury, so we'd need to go away and find out how the numbers trace through.
Yep, thank you. I know that in the previous budget, the 25-26 value of the line item was almost 300 million less than the same period in this budget. So in other words, you've spent 300 million more than previously estimated. What drove this upgrade in costs?
So which, are you looking still at the same table, Senator?
I believe, yeah, I think this has gone up by 300 million to the previous.
Senator, as Mr Harvey has said, we do need to go away and understand what line items have been loaded into this particular table. There was a one-off significant increase this current financial year due to the establishment of the trust fund with Nauru. That equated to about $400 million, which might explain a differential or a spike this year. But let us get you that detailed breakdown on notice.
Appreciate it. Yeah, because the reason for the question is it's gone up 300 million, but the forward estimates are showing it being at the same level. So I just want to see why there was a discrepancy and should it be included going forward.
So that payment to establish the trust with Nauru was a one-off, and we won't have that repeating in the out years. So that may well be the explanation. There are some other costs, particularly associated with regional processing, where they're provided to the department on an annual. The money is provided on an annual basis, so you will see them reflected in the next year only for some parts of our budget as well.
Yeah. Do you think taxpayers are getting value for money? Because it's on the number of people you gave me. I mean, it's not quite 1 million, but it's a substantial amount of money per person to have illegal people removed. Whether you encourage them to do it, or they do it themselves, or you put them in handcuffs and take them, it's a huge amount of money. So my question is, do you think taxpayers are getting value for money?
So, Senator, we're not going to be able to answer that question until we understand what it is that finance has put together. If it were just for the removal of people, then it would be one answer. If we've actually got a whole range of activities included in that, then we'll be able to give you a more detailed answer.
Sorry, but that's the only metric that applies to that line. But for people overstaying their visa, you wouldn't have to spend any money. So that's the only metric you can apply it to.
But not all of those people are necessarily removed or deported, is the point we're making. There's a lot more that is done using that funding than just that.
So I get that some of them...
Yes, absolutely.
I get some are forcibly removed and some are encouraged to remove themselves. But for those people, if everybody just went home when they were supposed to, there would be a zero in that line.
No, Senator, that's the point we're trying to make to you. That number doesn't make sense in terms of just being there for the removal of unlawful people. We think what's happened is that this booklet is pulled together by finance. We think that they have aggregated a bunch of measures and put them into that. Until we know what all the measures are, we can't advise you on the value for money question.
I look forward to seeing the breakdown. Thank you.
Sure.
Thank you, Senator Whitten. Senator Dunham looks like he's otherwise. I might go to you, Senator Bell.
I'll just follow on from some of those questions Senator Whitten was asking. And this is in relation to that 107,077 individuals that were being discussed. And you said there were at least, so some were visa overstayers, there were others. It was a broader category. So how many of the unlawful so you said, so just correct me so just to refresh my memory, You said not all of them were unlawful non-citizens, or are they all unlawful non-citizens?
So, just distinguishing, this row in the table, we think, covers the full range of our immigration compliance group functions.
I beg your pardon, I might just double check. I'm looking at the April, the department's April report. It is the, might be a monthly update, onshore protection subclass 866 visa processing, April report. Is that the same one we're looking at?
No, we'll get the right officer up to answer that question.
I think
Thank you for clarifying.
Groups, you were looking at money, yeah.
It's good to make sure we're looking at the same page.
Correct. So you said you were looking at the April.
It is, yeah, it would be the monthly update, onshore protection subclass 866 visa processing. The report covers the period of 1st of April 26 to 30th of April 2026.
Great.
And the figure you were looking at, Senator, was 107,000?
107,077. And so when I was listening on to the responses to Senator Whitten, and now is that cohort, is that all unlawful non-citizens?
No, they're not. That's a different cohort. So you're talking about some of those will be unlawful non-citizens. Some of them will be people who are still on bridging visas who are going through a review process. So it might be a review with the Administrative Review Tribunal. It might be a review with the court. So that figure is the number of people who've been refused a protection visa who are still in Australia.
And so the report refers to them as the total number of individuals not granted final protection visas that have yet to be deported. But that's not to say that all of them are to be deported.
That's correct, Senator. So we could give you the breakdown of within that cohort who's in each group. Would that be helpful?
I think that was what have you already agreed to do that? I would love that as well.
No, we can give it to you now. We have those figures.
Yep, I'd love to hear them.
The figures we have, Senator, are 31st of March, just so you know, so that'll add to a slightly different figure, about 106,000. So of those, 47,156 are at the Administrative Review Tribunal, 16,298 are at judicial review, and the remaining 42,436 includes unlawful non-citizens and those holding a bridging visa not associated with the review application.
So what was that last thing, 42,000?
42,000.
So of those, are they all unlawful non-citizens, that last 42?
No, some of them would hold a bridging visa E, I would expect, on a departure pathway.
So about 31,000 of those, Senator, are unlawful non-citizens or were unlawful non-citizens.
And so that means that they have been refused a protection visa and they would have exhausted all merits and judicial review avenues and have no outstanding protection-related processes, or would that group still be...
Senator, you're generally right. Some of them may not have sought merits or judicial review, but they have gone through that protection visa process, have not been granted a protection visa and have become an unlawful non-citizen.
So of that smaller group, which is, we agree, is roughly 31,000, so how many does the department regard as presently available for removal?
Senator, there'll be a range of circumstances in that cohort. Some of them may have been, because this is a point in time number, some of them may have been unlawful for a matter of days or weeks, some months, other periods. With our work to engage with unlawful non-citizens, we have a series, as I said before, activities to engage with them, to either connect them with a status resolution pathway or to encourage them to depart or to detain them, to remove them. I won't be able to break down that cohort in terms of who's removal ready, so to speak, but they are all required to depart Australia. They are unlawful non-citizens. We do expect them to depart and to make arrangements as soon as possible to depart.
So we're looking, so from April, which we're up at the figures from, to now, how many of that group have been removed or deported?
I'd have to take that on notice, Senator. Again, this is a point in time number, so that number people will have left and new people will have entered that.
And so, yeah, correct. But of the ones at that point in time that was reported, we don't know how many have been removed?
No. To give you a sense of the rate of flow for people who do self-depart, in 25-26, so to 31 March, so the first 9 months of this financial year, we've had 6,212 individuals who have departed Australia following a failed protection visa application process. So there is a cohort who accept the outcome and leave.
But in terms of people who are then required to leave or the government forces to leave, do we know that figure?
So we do know how many we have. We would be able to get you on notice a breakdown of the number who we have removed from Australia this financial year who had failed a protection visa process. And so if we get to the smaller numbers, that smaller cohort, and is the cost of managing that would have been included in the expenditure figure you were discussing with Senator Whitten? That's right. So we look to, we are going to the kind of heart of Senator Whitten's question. Our immigration compliance system is built on having a very hard edge, and that is people who do not comply will be removed, and via immigration detention if that's necessary. However, the vast majority of people we expect to leave before their visa expires because they have no further rights to remain. And that is what the vast majority of visitors and people who come to Australia do. That's our expectation. There will be a cohort who overstay, and we will typically contact them and say, you're overstaying, leave the country. And I think we've used the language of encourage. It's not exactly...
they're not nice conversations.
No, but they are very... It is really critical that we do have the final stop in that, being if you do not leave, we will detain you and remove you because you have no further right of stay. But that's the way our system's graduated, and we hope that most understand that it's much better to leave Australia on your own terms.
So just in these terms, does the department set targets? How much do these figures change? Are there sort of targets where we're looking for benchmarks of the people who refuse to sort of leave voluntarily? Do we have any idea of, is there benchmarks or targets? We don't have a numerical figure that says we're attempting to remove X thousand people. Because one of the things about removals is no two are the same. Some are really time and resource intensive. Others, such as removing someone to New Zealand, can be quick and cheap, and it doesn't throw up any complicated international law issues or other issues. So setting a numerical target doesn't necessarily cut to the heart of the problem. We need to invest out, and it could actually have perverse incentives where we would suddenly see effort going to, getting big numbers on easier cohorts, but not tackling some of the hardest to remove cohorts.
Final question.
Thank you. Thank you very much.
Thank you. Senator Duniam.
Thank you very much. If I could go to the process of granting visas, please, and just in broad terms, understanding the process one would have to go through and what the department does to assess someone's suitability for a visa. In broad terms, let's say a tourist visa.
Okay. I might start, but Mr. Willard is no doubt the expert. Senator, the process that is followed does depend. I think I'm glad you clarified and said which visa. It depends on two critical things to start with. Which visa, because as you can imagine, the intensity of the assessment process does vary quite a lot because we adopt a risk-based approach.
Yes.
So we will look at what visa, and then secondly, another key input is where you're travelling from. Every visa holder needs to meet a variety of checks, and I might explain to you. Go for it.
Senator, health, character and security requirements apply to every visa applicant.
What did you describe them as?
Health, character and security requirements. Right. In respect of a visitor visa, there's also an assessment of the individual's intent to make a genuine visit to Australia. This is a very high-level summary. There are a lot of regulations there, but in the broad, that's looking at the individual's background, looking at some vast data holdings that we have that we apply to every single application to determine the level of risk that individual represents. Ultimately, it's always an assessment of that individual's circumstances against the requirements for the visa.
And so health, what's the assessment there?
Health?
Yeah, you said health, character and security.
So health is a risk-based assessment. So for a visitor who's coming for a short period, that would normally be a declaration-based assessment.
Sure.
Some of their circumstances might mean that they require a medical examination. The sort of thing might be that they're going to visit a hospital, or perhaps they're a certain age, or perhaps they have indicated a health issue when they apply.
And character?
Character is the application of Public Interest Criterion 4001, which is known as the character test. The way we manage that, again, there's a declaration that the individual makes, but there's a whole series, layers of assessments that we apply to every application.
Every applicant makes the declaration that I am of fit character, whatever that is?
They answer a series of questions.
Yeah.
There are a number of layers to this assessment, and I won't go into minute detail, but at a high level, there's a match against identities and documents of concern. This is known as the movement alert list. And that has...
Well, who populates that? What's on that list?
So there's about something in the order of 2.5 million either documents or identities of concern. It's divided into a series of alert reasons, and it goes from everything from, for example, a terrorist, a very serious offence. The alert codes, I think there's about 20 of them, would include things like a debt to the Commonwealth as well, or other aspects that might be issues that we want to flag and resolve before we consider a visa.
So it's a wide spectrum.
It's a wide spectrum.
Serious crime to someone who doesn't pay their bills to the Commonwealth.
Visa cancelled.
Yeah. And we'd also look at visa histories, which would mean if we've dealt with the person in the past and had some information about that, that'd be relevant as well.
And does that, sorry to interrupt you, does that draw information from other jurisdictions? Is there some sort of sharing arrangement with foreign countries?
It's a alert mechanism which is the department and Australian government entities enter information into
domestic.
it. They may draw on international information in order to update the alert. So it's not like a foreign country is entering information directly onto the list.
No.
But if there's relevant information that should go onto the list provided by a foreign country, then that would be included.
Okay.
That's one layer. We also have an entity matching system. And entity matching is really any piece of information that's put in an application that can be matched. So we're talking about things like address details, contact details, emails, all those sort of pieces of information. There's about 3.4 million entity details that are matched again. And again, these will be indicators of concern. They in themselves don't determine the outcome of a decision, but they allow a decision maker to know, for example, that this person perhaps is using a contact detail that someone else has used at a different time for a different purpose. There's then a system called Safeguards, which is rule-based alerts, and we have around 1,000 rule-based alerts. These are broad profiles that give advice to decision makers on particular treatments of risk, or indeed treatments of low risk, because they identify both high and low risk cohorts. All of these are informed by vast quantities of data about what happens to each visa applicant who complied with their visa, who didn't, and that keeps informing these risk alerts. Finally, we have 43 predictive analytic models, known as a risk scoring service, that again draw on all of the information presented in the application and give decision makers a guide in terms of the level of risk that the application presents. That then helps them determine the intensity of processing.
Okay, and the application of all of those various layers you've gone through, is that uniform across all applications, or is there if you come, because as Ms Sharp said, you might come from jurisdiction X and that requires a slightly deeper dive?
So those risk systems apply to all applications, but the nature of them might mean if you're from jurisdiction X, a lot of those profiles might apply to you, whereas they won't if you're from jurisdiction Y. It's a very broad simplification of it, but
sure,
that's how it applies.
Well, we have all night. I don't think we'll go into the... We won't disappoint you, Minister.
Hour and 20.
Yeah, he's counting. So I want to go to a couple of cases of visas that were granted that, of course, attracted a degree of media interest. SNICO, Mizanur Azari and Sheikh Ahmadallah, who all had their visas cancelled. So I just want to understand how, particularly with regard to someone like SNICO, who I hadn't heard of until they were causing headlines, not my kind of guy, how does someone like that get through the system?
It won't surprise you when I say we can't comment on the individual case, but we can talk about how...
The generalities?
Yes, in more general terms. For example, a US citizen visitor visa could be processed if... Yes. And essentially...
So sorry, so because he's from the US, for example, that means there's one less flag?
No, I was thinking more about the nature of... So there's some visitor visas come in one way and others come in on the ETA system, right, on electronic travel authorisation, which means it comes in, it enters our system differently. Right. But as Mr Willard said, the same health security character checks are applied, but one of those flags will need to be triggered. And if none of those flags are triggered, then it's possible for the visa to be granted. And if subsequently new information or information is brought to our attention that didn't trip one of those safeguards or systems, then we will take action in result.
Okay. And so I know you can't answer specifics around an individual, but the case I referred to, the individual was here, so was here on the visa, I gather, and then had it cancelled while here. The human decision-maker element of the process you referred to, Mr Willard, you've got that predictive analytic set of models that you run information through and it comes out with a guide. What level of work does an individual decision maker then go and do? Because I assume in the example, the case I'm referring to, on which you can't comment, it's a high profile individual and the decision maker may not have, like I didn't, know who they were, but a quick Google reveals some pretty disturbing things. So what can be done to address that, or why did it sneak through?
A couple of comments I'd make. For probably more than 30 years, we've had a computer-assisted grant process, which means that where no flags are being raised in respect of particular applications, after going through that range of checks, that an application can go to grant without a human decision maker. All applications are refused, or refusals are by humans, but we've had, since about 1996, a system which allows computer-assisted grant, and that's a function of dealing with the volumes. What I would say is that we are constantly seeking to include further information that helps that system calibrate in as effective a way as possible, whilst also seeking to manage very, very large volumes of applications. And that's the circumstance. We're constantly recalibrating all of those checks and safeguards to try and identify applications that need more attention.
So, Senator, just to give you some sense of scale, we process just shy of 10 million visas a year, and I don't want to sound flippant, but in fact, it's more a surprise to me that we have so few problematic ones when you think about that volume.
Sure.
And I take comfort in the fact that when we do get information, because there is a human somewhere that brings that information to light, we are able to act on that very quickly and efficiently.
Yes, I mean, look, it would be ideal to have zero of, particularly when you read some of the things that individual said, and others I'll come to. But in terms of responses, you talk about recalibrating systems. So have there been changes made to deal with, and so I mentioned Mizanur Azari and Sheikh Ahmadallah. I mean, each of them, visa applicants, and I gather 2 were here successfully on a visa. 1 had a visa granted but hadn't yet come, of those 3, I think, from what I was told. Were recalibrations put into the system as a result of cases like this?
Yeah, there is a constant feedback loop, if you like, and that any case that results in a cancellation or another adverse outcome feeds into that approach and that risk system. In respect of particular cases, we certainly take learnings from looking at what happened in the particular case.
Yes.
Whether a human decision maker overlooked a particular issue, whether the guidance for that decision maker was right or not, whether the tools the decision maker has available to them were the right tools. So we do constantly refresh all those elements as well.
And with the cases, you may not be able to answer this, but with the ones I've mentioned, in terms of the learnings, was it human? Was it predictive guides? What was the...
Again, without wanting to go to a particular case,
sure.
We do, whether it's a human or whether it's a issue with the information on which the system's relying, we do take that into account and look at how it can be improved.
So over, the last 12 months, how many visas granted have been then revoked because of information received after the fact?
Are you getting it that could be a huge range of different types of information, ranging from the sorts of cases we've just been talking about through to somebody saying they're onshore studying a particular course, and in fact we realise they're not. They're in another country. You know, that is really common, and that is kind of what our cancellation area do. So we can give you.
Maybe if we go the variety I was just talking about, so those who, I don't know how you'd classify the examples I gave. What were the? Well,
so someone who, Senator, had we known the information, would have failed the character test.
Yes.
For example. Yeah.
Perfectly summarised.
Senator, in the 25-26 financial year to the 31st of March, so the last 9 months, the department made 48 cancellations under Section 501, which is our character provisions in the Migration Act. A number of visas were also refused under that provision, so about 435 visa applications were refused under those character provisions.
So they're the ones that the system picks up on the way, yes?
Or a human, yes.
Or a human, yes. Sorry, when I say system, I mean every part of it. Yep. 435. And what about for the year prior?
The year prior, for those discretionary character cancellations, the 48 I mentioned for this financial year, there were 43 in the previous financial year in 24-25, and 861 refusals.
Okay.
I should note too, Senator, that's not including mandatory cancellations, which are a subset of cancellations where if someone is convicted of 12 months or more after a crime and they're in prison, or it's a child sex offence, there's a mandatory legislative requirement to cancel their visa. That was 502 this financial year so far, and 831 the previous financial year.
But in the context of the issue you're exploring, it's the discretionary cancellations on character grounds that are
48,
relevant.
yeah. Yes, so not the mandatory ones, yes. So of the 48 in this year to date, this financial year to date, can you how did the department become aware of, I mean, do you break down how the information comes to light? Do you have some sort of record?
We wouldn't have that broken up, recorded in a way where we could give you data. We could sort of explain the various ways information, you know, like the various ways we become aware. It could come through a call to Border Watch. It could come through a ministerial office. It could come by way of occasionally a media inquiry. I think the, you know, the thing, and not to, that similar to what Ms Foster said, what's incredibly impressive is once we become aware how rapidly our teams in our compliance group can move through consideration, working out whether cancellation is needed or not, yes, or appropriate or not, and then move through our field and removals function. I guess.
And again, Senator, without wanting to labour the point, in the context of nearly 10 million visas, those numbers are small.
Yes. 0 would be great, but I take your point. And I know you're striving for 0. But,
of course, we always are.
Yes. Okay, look, that is very helpful. Do you... No? Okay, we'll keep going till 9:50. So...
Nice try.
Just with the forecasts of net overseas migration, if I can just go to those for a moment. So we, of course, had the MyEFO forecasts and then the more recent numbers, and there was a discrepancy of, I think, 55,000 between the two. Can I just get an understanding of how what goes into the, for example, in this case, the MyEFO forecast, and then the more recent set of numbers, and in, 6 months, how things can change to that extent?
Senator, as we've talked with this committee about before, responsibility for the non-forecasts sits with the Treasury.
Yes.
And that they own the model. So questions about the detailed methodology they use and why the forecasts can change really should be directed to them. We work closely with them because obviously our data sets on visa grants and arrival dates and departure dates are highly relevant to their forecasting, but the reason why they might have changed from budget to MyEFO and what you might expect next MyEFO is a question for Treasury.
All right, well, I can ask them that, of course, but what other input do you, I mean, you obviously work with them, what other inputs do they have beyond things like visa grants, arrivals, departures, etc.?
I think a key point to make is net overseas migration, of course, is not just about visa holders.
No.
So there'll be a whole, and look, I don't want to talk about Treasury's model, but I'm sure there's a whole range of indicators that go, economic indicators that go to drivers of those movements.
Yes.
That would be relevant. We certainly work very closely with them in terms of the visa numbers, what we're seeing. We share data, and we also look at every visa policy decision Treasury has input on in respect of considering how it might be impacting net overseas migration.
Sure. Okay. Well, to the extent that Home Affairs makes contributions to Treasury's work, what's the which visa categories have contributed most to the change in the latest budget, the latest numbers? Like, can you talk about, because there was a 55,000 differential, what drove that?
I think there was some commentary around the time of the budget around people leaving at a slower rate than anticipated. Mm-hmm. Of course, you have your ins and your outs.
Yes.
So there was reference to that. We do have some figures in terms of impacts of particular programs. Students, for example, is a big impact.
What figures do you have there?
And for the 12 months to the 30th of September 2025, we've seen non-arrivals down 7% and non-departures up 33% and total non down 18% for students. So there's a trajectory there, whereas a number of years ago, well, 2 or 3 years ago, NOM numbers, students was one of the main contributors to the growth in NOM.
Okay, so students, no other standouts in terms of those figures that you'd...
And these are, we're
I
drawing...
know they're only a part of the whole thing, but...
Yeah, I think, I guess if you look at variations, the other key reduction in that reporting to the 30th of September 2025 was visitor non-arrivals, which fell by 26% in that period.
Yes, so just on that, I mean, you've got the raw data there, so that is tourist.
Yes,
visits,
essentially,
yeah.
and visiting family and business visitors. And,
Yeah.
But that is obviously, if they're in NOM, it means they've nommed in, so they meet the requirements.
In plain English, that means that is not a visitor who's come to Australia for a 3-month holiday.
Yeah.
That's not the figure that's declined before we put... someone is a visitor who noms in if they're in Australia for
12 and 16 months. So what you're seeing there...
12 over a 16-month,
So
12
they
months
would-
over a 16-month period.
Okay, and they would typically be...
Typically, you'd see what used to be able to happen. There have been changes to this,
Yeah.
which has contributed to the reduction in NOM, was that you could come on a visitor visa and you could then apply for a student visa.
Yes.
So whilst the visitor visa is a relatively short period, of course, once you move on to the student visa, you then get to that 12-month period where you're able to nom in.
Nom in, okay. All right. So what are the current numbers of temporary visa holders in Australia? Do you have an aggregate figure?
I do.
Onshore?
So the figure as at 31st of March is 2,994,000. I would say in temporary visa holder counts, we do include New Zealand citizens who hold a special category visa. They're the largest cohort. There's 732,000 of them.
Of that 2,994?
Of that 2,994. And there's a range of other categories in there as well.
And categorised by nationality or?
Oh, by visa
Visa
type.
class,
temporary
okay.
visa type.
Or type, sure. Okay. And how many people are currently on a bridging visa?
Bridging visa is same date, 455,000. That's the 31st of March. I may even have a more up-to-date figure on that one, though. I think I might have the end of April.
Senator, just while Mr Willard finds that figure, not
Yes.
all of those 2.9 million will be counting towards NOM.
Because they don't nom in.
They don't necessarily. There'll be a lot of visitors in there.
So for complete clarity, that's a point-in-time figure on a given day.
Yes.
It could be someone visiting for the weekend
Yeah.
on a holiday. They just happen to be in the country on that day.
Sure, okay.
So the figure at the 30th of April is 441,000.
The more recent, 441
That's the bridging visa
of
figure.
bridging, yeah. And for, you won't have the same figure for last year because it'll be for the full financial year. What was it in the last reporting period?
Let me see if I can get that for you. I think I gave you the March figure, which was 455.
Yes.
But you're looking for the 30th of
Or
April,
whatever,
2025?
yeah, you've got. Do you want to?
Yeah, I might have to take that on notice, Senator.
Oh, I can keep going. You want to share?
The full year figure.
Figure out.
Oh,
It's a point-in-time
these are all
figure.
point-in-time figures. So, Senator, these are all point-in-time figures.
Yes.
So each day it's a different number, depending on who's entering
This
and
is
leaving the country.
exhausting. Yes. Okay. All right. Well.
Mr. Kiley's pointing out we do have some figures. So look, the closest one I've got to the previous year is the 31st of March the previous year, and that was 406,000.
Okay. So it's
Comparison
around
point, it was 455 on the 31st of March
Yeah.
this year.
It bounces around, similar sort of area. Okay, thank you, Chair.
Thank you, Senator Dunning. I'm going to do a stock take of his questions and figure out how to get us out of here by 8:30. No, I'm joking. Senator Polly's got some questions.
Thank you, Chair. I just want, can you outline the process for getting a skilled visa for Australia?
Certainly, Senator Polly, there's a number of different types of skilled visas. I might quickly talk about the temporary skilled visa to start with, which is
That'd be useful, thank you.
Employer-sponsored visa.
Yep.
To get one of those, an individual would need to, first of all, the employer would need to be approved as a sponsor. An individual would then need to be nominated for a particular skilled job, and it's determined as skilled based on advice from Jobs and Skills Australia, whose advice goes into the list of eligible skilled occupations. Then that person would need to meet requirements around salary. So there's they must be paid essentially the market salary rate, the same rate as Australians, and that must be above the salary floor, which is about $75,000. That person also has to meet English language requirements. They then get assessed against the health, character and security requirements that go to every visa holder. They have to pay a fee. Their employer has to pay a Skilling Australians Fund levy fee. There's an assessment of their skills to make sure they've got the right skills for the job, and then if they meet all of those requirements, the visa is granted for up to 4 years. Permanent visas, there's a couple of categories. One is the what we call human capital categories. These are points-tested visas and state and territory nominated visas. Someone will put into an expression of interest system all of their skills and attributes, and they go to things like their age, their language level, their qualifications, their work experience, and a whole range of other factors that come into play, which is really a way of determining what sort of level of human capital they're bringing. They also need to be assessed as meeting skills requirements in a skilled occupation. You know, if they're a medical person, that might be going through the medical practitioners assessment body, or whatever that skill might be. Again, they have to meet the health, character and security requirements that apply to every visa holder. If they're in that EOI system, all of those attributes are given points, and if they have a very high point score, that's an indicator to us that they have a high level of human capital, and they might be invited to apply.
So can I ask then, who can actually sponsor a skilled worker? What's the requirement?
You have to be approved as a sponsor, so it's most Australian companies would be able to be a sponsor. They have to meet a range of criteria though to be able to be approved for sponsorship.
So how are the occupations selected for a skilled visa?
It's based on advice from Jobs and Skills Australia. They do a whole lot of labour market analysis and determine what are the occupations where the need for that occupation is best met by skilled migration. These are all skilled occupations, so it's in the higher skill end of occupational classifications.
So what would be the most common occupation that is applied for?
When we look at outcomes, nurses have been the most common occupation. There's a lot of efforts from state and territories. There's a lot of efforts from employers to recruit nurses. We see a lot of accountants. We see a lot of chefs in the hospitality sector and a lot of IT people.
So is there any difference between rural and regional areas compared to cities in terms of the skilled visa being used?
There are some differences. We do still see a lot of medical professionals in regional areas.
So just, I'm getting the wind up, but adding to the percentage of nominated skills, how many skilled visas are out that people are using them? The family visa, working holiday makers and student visas. Can you give us the percentage of those visas?
As in what percentage? I don't.
Of the visas that have been allocated, how much is broken down to skilled visas?
Oh, okay. So in our permanent migration program, it's about 70% skilled visas.
Right, okay.
Thank you, Senator Polley, for that efficiency. Senator Roberts.
Thank you, Chair. Back to the topic I started on this morning.
Great.
It's an immigration issue, not a health issue.
Yes, Senator, we'll just get our Chief Medical Officer up to the table.
Senator, I could speak broadly about the criteria. So there's a health criteria that applies to all visas. It looks at questions of health protection for Australians. It looks at costs to the health service, and it looks at the access to health treatment for Australians. It's applied across all our visa types. It's applied on a risk management basis. So it looks at where somebody's coming from, the sort of health risks that might be presented. It looks at what the person might be doing in Australia, whether they're going to go to a medical facility or whether they're staying for a short time or looking for a permanent visa. So all of these factors are taken into consideration when the health criteria is assessed. Dr Grant Pegg's our Chief Medical Officer. He oversees the system that undertakes medicals, and I think there's very large numbers of medicals undertaken each year.
Okay, so I'll ask the question. And then could you tell me the three criteria again, basic criteria?
So it's preventing. So it's health protection for Australians. It's costs to the health system, and it's access to health services to Australians.
Okay, this is primarily with number 2, cost. The 2026-27 federal budget included $68.5 or $69 million over 3 years to provide HIV treatment and pre-exposure prophylaxis, which is medication that stops transmission, to people in Australia who are not eligible for Medicare. Not eligible for Medicare, but we are paying for their treatment anyway, so they don't infect Australians with HIV. Is that the logic behind this allocation? I know it wasn't allocated by you, but
because it is a measure from the Department of Health, I really can't talk to the logic behind the measure.
Why should Australians allow entry of people with HIV and then pay for the treatment, especially when Australia is under pressure economically and individual Australians are under pressure cost of living wise? Why should...
Senator, I think again Mr Willard's unable to comment because the measure was developed by Department of Health.
I think that the right place is community affairs next week, Senator Roberts.
I want to know, many Australians are calling for non-citizens who have HIV or AIDS to be deported instead of paying for their medical care. We're letting people in here with a known liability cost to Australians. What is your response to that criticism of this budget allocation? The criticism, not the budget allocation itself. People are concerned that we're letting in people who have a disease and now we're paying for their treatment.
Senator Roberts, I think that is asking the officials at the table for their opinion on a matter that is not within the permit of the questions allowed to ask at Senate estimates, particularly as it relates to the budget.
I'll move on to the next one. Australia raised the significant cost threshold for visa health requirements in July 2024 from $51,000 to $86,000. For those following this thread, I'll give a quick explanation. The significant cost threshold determines whether a health condition such as HIV, AIDS or physical disability is likely to impose significant costs on Australia's health and community services. Exceeding it typically means failing the health requirements for a visa, although health waivers are available for some visa subclasses, including partner and humanitarian. A person who comes in under your new cap, higher, can access medical care and medications for free or for a small co-payment depending upon the state in which they live. How many people are here under this arrangement across all conditions, all health conditions?
Hi, Senator Grant Pegg, the Chief Medical Officer. I don't have the data in that detail, so I'd have to take that on notice.
Okay, if you could, thank you. And you're the Chief Medical Officer for the Department of Home Affairs?
The department, yes. Yeah.
Isn't this, this is my last question, Chair, on this topic, isn't this a perfect way of getting a family member into Australia and having their care paid for straight away? And the other part of the question is, and the numbers are increasing, which means the Australian taxpayer is paying more.
So perhaps if I can just offer that that's the purpose of the operation of the significant cost threshold, is to try and avoid significant cost to the Australian healthcare system. So that's why it exists.
Could you explain that more?
So when someone's identified as having a health condition through the immigration medical examination as part of their visa process, they're then costed by a medical officer of the Commonwealth who looks at that at a hypothetical basis for someone with the same condition, the nature of condition and severity, to determine what their costs might be to the Australian healthcare system. So that could be lab tests, x-rays, visits to the doctor, those sorts of things. And there's a comprehensive process that's undertaken to do that. And when that's undertaken, a figure is determined, and then if that figure exceeds the number that you talked about, $86,000, then that's considered to be not meeting the health requirement.
So the first part of my question, isn't this a perfect way of getting a family member into Australia and having their care paid for straight away?
Are you talking about in a situation where the health requirement is waived, like somebody does? But I guess what we're saying is the general rule is if you fail the health requirement, as in your healthcare costs are coming in above $86,000, you will not be granted the visa. You won't come to Australia.
That's initial assessment, but isn't this, forget about the payment matters, but I'm not interested in the total amount. What I want to know is, isn't this a perfect way of getting a family member into the country and having their health care paid for straight away? That's basically what it is. And the government's allocated $69 million over 3 years to provide treatment and pre-exposure prophylaxis just for people with HIV. Coming in here, known condition, and we pay for the treatment.
Was there a question, Senator Roberts?
Senator,
Isn't this a perfect way of getting a family member into Australia and having their health care paid for?
Senator, I think this is a question that the officials at the table have responded to. It sounds like they're not necessarily...
yes or no?
You're not talking this... You're not using the same words to describe the same thing. I think the officials at the table have been spoken about what their role is. I think you're talking about it in a different way, but it's not necessarily what the officials are.
It's about immigration, though.
Yeah, I think they've responded to your question, which is there's a program that exists to essentially weed out, for want of a better term, people who have costs higher than the amount that the officials said.
If they're projected to have a significant cost threshold higher than 86,000, then I understand. But if it's less than 86,000, isn't this a perfect way of getting a family member into Australia and having their care paid for straight away?
Senator, I don't understand the link between the answers we've been given and the
Yes or
family
no?
member issue. That's why we're struggling to answer you.
Yes or no?
Senator, we don't understand the relation of the question to the information we've given, and in a sense it's asking us for an opinion about, is this a perfect way to do something? That's not our role. Our role is to provide you with information about how the program operates.
I'll make it easier. Is it a way of getting a family member into Australia and having their care paid for straight away?
Senator, we might finish it where we began, which is I think you need to direct this question to the Department of Health to ask them for the policy reasoning behind the measure, which group of people they were aiming to support.
So we apply our immigration rules irrespective of whether or not the government has funded a measure such as this through the Department of Health.
One of your immigration rules covers a significant cost threshold of maximising at 86,000. So if you assess an application to migrate here and it's less than 86,000, then they are welcome in.
Senator,
is it a way of getting a family member in here?
We don't understand the relationship between what we've told you and the question about a family. I can't say that any more clearly. I'm not trying to be unhelpful. We just don't understand the question.
Could a person residing, a citizen of Australia, use this to bring in someone who is going to cost Australia money and healthcare immediately?
Senator, the rule would apply irrespective. So we would apply that rule as part of our visa consideration to any visa applicant.
I understand that, but this is a way for a citizen of Australia to bring in a family member and have their health care paid for by the taxpayer.
Senator, I'm sorry, but we have nothing further to add.
Okay. Thanks, Chair.
Thank you, Senator Roberts. Senator Duniam.
Thanks, Chair. Okay, could we go... Do you keep data on the number of decisions that you've made that then go to the Administrative Review Tribunal? You do? Do we know how many of the last 12 months, or whatever reporting period you have closest to that, where there's been instances of visas cancelled on character grounds have been set aside by Home Affairs, and how many have been affirmed by the ART?
We do track that very closely, Senator.
Excellent. My office would be happy.
It's one metric we keep a very keen eye on.
Senator, I can give you the yearly breakdowns if that
why not?
assists. So for this, starting with this financial year, 25-26 up until the 31st of March, we had 264 cases where the department win.
With the big pardon? So the department what?
Won the case.
One, right.
And 196 where the department had a loss in the ART. And those are for character-related decisions.
Perfect. 24-25.
247 where the department had a win, so to speak, and 128 with a loss.
Okay. Do you track those that go beyond the ART into other courts as well?
I don't have those figures in front of me, Senator, but we do.
Mr Frack may well have those and our outcomes at judicial review.
Peter Frank, Assistant Secretary, Migration and Citizenship Litigation. Senator, I don't have all of the character results at judicial review. I've got a subset that's in relation to decisions where the Minister has decided to set aside a decision of the tribunal, and then that's gone on to judicial review. Let me just turn those up for you.
Thank you. And then would you, on notice, be able to provide the broader... Yes.
Yes, certainly, Senator. So the data I've got here, it's not broken down by financial year, so it's from May 2024 up until the end of March this year. Mm-hmm. We've seen 142 challenges in the courts to ministers' personal set-aside decisions, and I don't have the breakdown of the results for those by win and loss, but I can certainly get those on notice.
Yeah, that would be very interesting. To know where those ended up. Well, look, on notice, that plus the broader numbers would be helpful as well, consistent with Mr Thomas's pieces of evidence there, please. Last week, it was, I think, in the Daily Telegraph, there was a report that there were at least 73 migrants, some of whom had multiple criminal convictions for extremely serious crimes, having successfully overturned their visa cancellations at the ART in the last 6 months. So are you aware of that reporting at all? Did you come across that, Ms Sharp?
I think I did.
Okay. I mean, does that figure ring true to you?
Senator, I think as you just heard from Mr Thomas, there is a flow of decisions where the ART disagrees with the original or makes a new decision and decides to reinstate a visa. I think, and so, yeah, it's certainly, the figure didn't surprise me in that, as you heard, we track this number very closely. And
what do you do with that information? So we have these situations where the ART or through judicial review there's a disagreement. with the original decision. What do you take from it?
When the decision is made by the ART, generally our colleagues in legal group typically will send around an email very quickly, within usually 24 to 48 hours, with high-level note, here's this person. That then gets escalated to work out whether there's interest in using a ministerial ART set-aside power because the Migration Act works in such a way where the department takes the original primary decision, the ART can then make a decision on the merits and make a second decision. There is then a power for the minister to step in and cancel again. So our process is very quickly after we receiving an ART decision to grant, we give the Minister's Office a heads up that that has come in. If there's an indication that, yes, they would like to set aside, we then, from Immigration, prepare the appropriate ministerial submission, setting out all the facts so that the Minister can consider in detail the case.
And just with regard to the ART, I mean, obviously they're an important function in society and have a degree of power over people's lives in response to government decisions. What interaction is there between the department and the ART around perhaps training or trying to educate members of the ART around why decisions are made a certain way and how the rules work?
Senator, as you're probably familiar, the Minister of the day can issue a direction to guide all decision makers in how he or she considers the power should be exercised. That's I guess the primary framework that all decision makers, whether they're the departmental or the ART members, need to work within. In terms of then sort of tracking, we expect that there is always going to be some level of divergence because it's a decision on the merits.
Sure.
So reasonable minds may differ about how you weigh up the considerations outlined in the ministerial direction.
It's also a de novo decision.
Yeah.
Yes.
And so someone may have been refused because they didn't have particular documentation, which they now have, or they didn't have the required English language level, but they now do.
Yeah. So in terms of engagement with the ART, we don't typically engage with them on the substance of their decisions, but we do meet regularly with them to talk about process, to try and iron out, making sure, because what really matters in the visa system is when decisions are overturned, that we're efficiently notified and it's tracked so that people don't go unlawful in the intervening time. And we do focus very heavily on making sure if there's a systemic issue that's leading to a lot of decisions going one way or the other, we do talk about that at a systems level.
I guess that's what I'm getting at, is if you see a pattern, what response is there? And
we do engage and try to understand the reasons, and I guess in the, you've seen it with the work that's been happening between the ART, Attorney General's Department and ourselves on students, where that actually ultimately led to us identifying that the law itself needed to be changed to give the ART more powers to be able to deal with cases more quickly because of the volume.
Yes.
And of course the Minister can change the ministerial direction if it becomes clear, because obviously any case that's overturned by the ART or where they disagree with our decision is a case that we have, with the same ministerial direction, already decided to refuse. And so if it's being interpreted differently, we ask ourselves the question, does that direction need to be written in a different way to mitigate if that is not the intent of the direction, is there a better way to phrase it?
And Senator, I was going to make the similar point to Ms Foster. It's just important to remember that those decisions of the ART to overturn a cancellation by necessity involve, there has been a decision by the Minister or the Department to cancel a visa. The ART is then overturning that decision, and many of those ART decisions are then overturned by the Minister.
Yes.
So the whole thing relates to a decision having been made to cancel a visa in the first place.
Yes, I think I was more interested in that, where there is this divergence and a pattern perhaps where the ART is going off down a pathway and that requires response as has been described. So
And that's why at the very outset I said we track those numbers really closely, because we are watching the pattern and the divergence, and if at a certain point we judge that the divergence is getting too great, that is when we would approach a minister and say we think you need to change the ministerial direction because to make this aspect clearer, because we're diverging in a way we're applying your direction.
Perfect. Can I go to the complex and controversial cases section of the... Yes, how many members are in that team?
Senator, if you're referring to our controversial visitor unit, so it's a team that consider visa applications from quote-unquote controversial visitors. I don't have the exact current staffing footprint. I might have to take that on notice to give you an exact number, but Ms Bird might be able to assist me with an estimate of the staffing number.
And just while
we'll take it on notice.
We can do that. How do you determine who is a controversial visitor?
It can include a range of different people. Typically it's high-profile individuals with a criminal history or controversial views. Anyone likely to attract significant adverse media and public attention. Visa applicants or holders whose presence in Australia might be contrary to Australia's foreign policy interests. And a range of other people. So it is quite a varied definition. We don't try and restrict it too much to make sure that we are considering
someone's got to make a determination. Yeah. Okay. So you will, on notice, find out for me how many people are actually there now, and perhaps for the last since 2022, how many people have been employed in that team?
Yes, Senator.
By year, if that's okay. Do you have a number of cases per annum that this team look at?
I can give you a sense of the number of cases they've assessed, just going by calendar year. So in the first 3 months of this year to 31st of March, they considered 114 cases. Mm-hmm. In 2025 calendar year, 470. The 2024 calendar year, 182.
Okay. I'm trying to, 182, that's what, one every 2 days, 470, that's one point something a day. I'm just trying to, because there has been commentary that there's a resourcing issue in that team, and that's why I ask those questions around how many team members there are. Do you even have a rough idea, that noting it is being taken on notice? Are we talking 5, 10, 50?
I'm a bit hesitant to guess, Senator, just in case I do get it wrong. I should note the CVU, the controversial visitor unit, is a part of a bigger architecture as well. So
do they work with others outside of the
they absolutely
team?
Do.
Okay.
I think that's a really critical point, because the controversial visitor unit are where, once somebody's been identified as being potentially controversial, the cases go. But the system, Mr Willard talked to you earlier about, that picks up and tries to identify using those range of tools built in, other detectors, if you like.
So is that how we determine who goes there, in effect?
That's right. That's right. So a visa processing officer anywhere in the world might think this case looks like it's triggering a flag. This person looks like they might be saying controversial things, and then it'll get sent in. Sometimes it's obvious, and that doesn't even need to get to the controversial unit as well.
Ms Bird's come to the table.
I have.
Hello.
Chloe Bird, First Assistant Secretary for Character Cancellation and Case Resolution Division. I don't have the figures for you since 2022, but currently we have 10 people in the team that we're talking about.
10. Okay. All right. And that, look, again, I've asked on notice, but that's a relatively static number.
I think so.
Yep. Okay. All right. That is what I needed. Okay, there's an XPLW case. Is anyone at the table familiar with that one? No. And I will one day want to know how we actually define the nomenclature rules around these cases, because...
It's the court system. We don't do that.
Well, let's bring them in one day and ask them.
Senator Dane, just checking on time. Senator Roberts has got another line of questions.
Okay, I'll ask this question and then I might be very close to being done. So in that case, and you may have to take it on notice, I'm not sure, but it was reported to me that there was a delay of, or a period of time rather, of 18 months between December 2022 and June 2024 when the department's controversial case team didn't consider the matter. And so I was going to ask what would be the reason for that delay. Now, I know that there might be, and one, you can't talk about specific cases, I know, but would it be because you're awaiting information or what? Like 18 months is an exceptionally long period of time.
Senator, this is a bit triggering for us. But at that time, we had a very significant backlog, which was not visible to us at a leadership level,
right,
and became apparent when there was a case where someone who had their visa reinstated by the ART committed a heinous crime before they were considered. We have put an extraordinary effort, which is one of the reasons why Ms Sharp keeps saying we watch this very closely, into ensuring that we do not get into that situation again.
Yeah.
And the case, and Mr Frank may be able to add to detail, that you're referring to, it's a legal case, so I'm not going to talk about the facts of an individual person, but the point in question was, or the question is there any sort of time limit imposed on the time between when the ART sets aside a decision and when the Minister uses his power to overturn that?
Okay.
And we won that.
Well, look, if there's anything
case.
else to add, do so on notice, I think, is probably the safest way to go with that one. Thanks, Chair.
Appreciate your assistance, Senator Daniel. Senator Roberts.
Thank you. Thank you, Chair. My questions are about the citizenship backdoor between New Zealand and Australia. Changes made by the Albanese government in July 2023 allowed New Zealand citizens who have lived here for 4 years to become Australian citizens without having to first become permanent residents. Is that correct?
Senator Mr Leighton is joining us.
Drew Leighton, Acting First Assistant Secretary, Citizenship, Humanitarian, Family Visa Programs and Support Division. Technically, that is correct. The 444 visa holders are categorised as a temporary visa. They do have since that time become eligible for citizenship.
Thank you. And a New Zealand citizen can come here without a visa and automatically qualify for a subclass 444 visa. That's correct?
No, that's not correct, Senator. The 444 visa is applied upon arrival to a New Zealander, so they obtain that when they arrive in Australia.
Can they get onto, basically that's the same as a permanent visa?
It's a temporary visa, the 444, Senator.
Is it effectively a permanent visa they can stay?
So they can stay indefinitely, but it's classified as a temporary visa.
Yeah, okay. I don't know why that's the case, but let's leave that. They can stay indefinitely. Then after 4 years, so they arrive, get a 444 visa staying, making them stay indefinitely. Then after 4 years, they can get citizenship without getting a permanent visa, straight from subclass 444 to citizenship. Is that correct?
That's correct.
Thank you. We really are just relying then, are we, on New Zealand having the same standards for citizenship as Australia?
Senator, this was a government policy decision. We are responsible for giving effect to it.
And it's worth recognising, Senator Roberts, that many, if not most of those New Zealand citizens who are gaining Australian citizenship have spent many years in Australia working, paying taxes, those kinds of...
I recognise that. I'll go on. Do they, though, in New Zealand, because you may become a citizen in New Zealand if you've been there 5 years. You can hold a conversation in English and are of good character proven with a police check. Summary offences don't take away your good character. That's the bar these people are using to become Australian citizens. Yes, some Kiwis are here for 20 years. It's annoying that they don't become citizens, but there are certain loopholes to certain benefits not becoming citizens. I'm talking about people who use this as an easy entry why New Zealand is now the #1 source of Australian citizens in the 2-year period from 1st of July 23 to 30th of June 25. So it is an easy backdoor, isn't it? For someone who's come to New Zealand and come straight here.
So again, Senator, I think you're asking us for an opinion. We can give you facts about the system, but we can't comment on assertions of that nature.
They can do that, can't they?
So, Senator...
I'm not asking for your opinion. They can do that. Thank you.
Technically, someone can, as the officers have said, come to Australia on a 444 visa, and after 4 years they can apply for citizenship.
But noting they would have had to have met the time threshold in New Zealand to acquire New Zealand citizenship as well.
Yep.
So,
but that's at a very low threshold, low bar. So in that period, from 1st of July 23 to 30th of June 25, 48% of New Zealanders who are now Australian citizens were not born in New Zealand. They came into New Zealand from overseas. That's a backdoor entry to Australian citizenship with a much lower bar because they had to meet the threshold for New Zealand, which is lower than Australian citizenship. That's a much lower bar than people moving here directly and following the rules in Australia to citizenship, including passing what is called our 100-point test with at least a score of 65. This New Zealand backdoor is way easier than getting 65 on the 100-point test. Just for clarity, children don't generally need to pass a citizenship test. Can you clarify that rule by age, please? What's the age threshold?
Senator, it's 18.
Thank you. Do you understand the position that offering this pathway to people from foreign countries to come in through the back door in New Zealand without passing the points test is a slap in the face for those who have come here fairly, waited, worked, studied and did the right thing but can't get citizenship because this government rode a backdoor way for no obvious reason? Can you understand that?
Senator, we can't comment on opinion of that nature.
I have to say, I think it's pretty insulting to a lot of New Zealand citizens who become Australian citizens to talk about them coming through a back door.
I'm talking about people who come into New Zealand, meet the lower threshold in New Zealand and come here. That's who I'm talking about, Senator Watt. I'm surprised you can't work that out. If this was about working with our neighbour New Zealand, why wasn't there a provision for the pathway to only be open to New Zealand-born people rather than to deliberately set up a backdoor to let in people that couldn't pass a points test? What was the reason for that?
Senator, the policy and the parameters around that are a matter for government.
Minister?
Well, I'm trying to remember the reason the government made that change in our first term. My recollection is that it was partly in recognition that there are, because of a change that had been made by the Howard government, that there are a very large number, or were a very large number of New Zealand citizens who had lived in Australia, as I say, worked, paid taxes, contributed to the community in a range of ways, but despite having lived here for a very long time, they were unable to get Australian citizenship because of rules the Howard government imposed. That, in our view, was not fair. So I remember that being at least one of the motivations for changing the policy.
So I've got no problem with that. What I'm talking about is people who come to New Zealand, quickly meet the lower threshold for citizenship there and come here and automatically get citizenship.
Well, I'm not sure that people who, as you say, move to New Zealand and then move to Australia are necessarily of low standard. And that's sort of what you're implying in your question.
And Senator Roberts, I would also suggest that the New Zealand citizenship process is not a matter for Home Affairs here.
No, it's about using that threshold for people who are new to New Zealand. How many citizens have been awarded citizenships have been awarded to people without passing the points test under any circumstances?
Sorry, the points test?
Senator,
the Australian entry citizenship
the points test is one way somebody can gain a permanent residency in Australia, but not every person who gains permanent residency in Australia comes in as a points tested migrant.
So how many come in without passing the points test?
Senator, I would have to take that on notice. I would note, though, there's also employer-sponsored migrants. There's many different types of permanent residents.
If you could, please, thank you. I'll just quote from an article here. It's also prompted New Zealand Foreign Minister Winston Peters to flag concerns his country is being used as a stepping stone by migrants wanting to come to Australia, and that the trend will further accelerate under an easing of its own migration rules, which will grant residency in just 18 months for some workers. Winston Peters is concerned because he doesn't think, he also says here, those numbers combined with the recent rise in New Zealanders moving to Australia have raised doubts about Australia's ability to meet a planned slowdown in migration. He doubts whether you're going to slow down, as well as concerns it's robbing New Zealand of both its professional and low-skilled workforce.
Well, for starters, Senator Roberts, migration numbers in Australia have significantly fallen over the last couple of years.
Compared to when?
What's
the baseline?
Compared to the surge that we saw after COVID.
You mean the surge in 23, 24?
Yeah, that was the surge that happened after
Your
COVID.
surge, where you went from 500 to
the surge
750?
that followed COVID.
Senator Roberts, we have been very orderly throughout today, and you are usually pretty good at not interjecting, and I would ask that you maintain that order and allow the ministers to respond, please.
And just a couple of other facts about this situation, Senator Roberts. I think we've already heard that the process that now applies still requires a person, someone who has moved to New Zealand and gained New Zealand citizenship. They are required to have that for 5 years. So they spend 5 years in New Zealand and then 4 years in Australia. So if you want to characterise that as a backdoor, that's a pretty slow backdoor. And the second point about, you've been asking questions about the points test. Any Australian person who wants to get Australian citizenship still needs to meet the character, identification, security tests as well. So I don't think as I said earlier, I think it's a bit insulting to be suggesting these people are running through a back door and are of low standard, and that's what you're suggesting.
There's a bloody long garden path leading to that back door.
I've worked and lived in New Zealand, turning around a business there for 12 months. They're wonderful people. But Winston Peters is concerned that their immigration system is being used for quick entry into New Zealand to go to Australia.
And that's a question for New Zealand to address.
Yeah. And it's also a question for Australia to address, and that's what I'm doing on behalf of the taxpayers. Minister, I'd agree with you on one point. Mass immigration was started by John Howard's government. It's pretty much doubled since then to Scott Morrison's government, and then you have tripled it in the early days, 23, 24.
Actually, what's NOM stand for again?
Net overseas.
Net overseas migration has fallen by 45% over the last 12 months, 18 months. I can get you the exact
You
time
had
frame.
2 very high years, a low year, and now a very high year again. You're playing with numbers.
It's another one of those ones. We're never going to convince you, but...
Senator Roberts, have you got a question?
I go by the data.
During COVID, migration crashed. After COVID,
correct,
lots of people came home. Migration rose. We have now reduced NOM by about 45%.
That's misleading, Minister, because it increased
facts.
dramatically under Morrison to re-establish what he thought was the right numbers of migration. Then you almost doubled it, then you decreased it slightly, and now you're doubling it
So
again.
we should have told all those Australians who wanted to come home after COVID that they weren't allowed home.
No,
Sorry,
I'm
can
talking about
I
immigration.
just interject for a
mass
second
immigration,
here?
mass
Senator
immigration.
Roberts, I am not hearing any questions from you. Can I take it you have finished this line of
Yes, you
questions? Thank you very much. I will now go to Senator Shoebridge.
Thank you, Chair. There's a variety of internal New Zealand policy issues that I'd like to discuss. We'll do them later.
All Canadians.
Could I ask questions about the visas that have been granted to the Palestinian ambassador and his team? Is it right that generally diplomatic staff, specifically ambassadors and or high commissioners in Australia who are on here inevitably in temporary work, get the temporary work international relations subclass 403 visa. Is it called the government agreement stream or something?
Senator, I don't know the details of the specific person you mentioned, but generally diplomatic representatives have a subclass 995 visa, which is a diplomat visa.
And they get that visa on the basis that they're part of recognised ambassadors and diplomatic missions in Australia.
It'd be on the basis of accreditation by DFAT for that purpose, yes.
Yeah. Australia recognised the state of Palestine on the 21st of September of last year. Since that recognition, can you advise what visa classes the Palestinian ambassador and his diplomatic staff have been granted?
Senator, I'm afraid we can't discuss particular individuals. We can tell you, as Mr. Willard has, what the normal process is. But
I'll ask for the Palestinian delegation, because it's my understanding that the Palestinian delegation has been refused access to the government agreement stream and have been forced down this thing called a foreign government agency stream, which is given to, which says in its criteria, with this visa you can work as a representative of a foreign government agency that does not enjoy official status in Australia. They are still trapped in a visa stream which is only given to foreign government agencies that do not enjoy official status in Australia.
Senator, I'm not aware of the details, but it does sound like it's an accreditation question, but I just don't have the details of that particular delegation.
So when it comes to the visas that you award to diplomatic staff, is the gatekeeper DFAT in terms of accreditation? If they accredit a mission, an embassy or a high commission, that means different visa classes are available than if they're not accredited.
The visa I mentioned is issued on the basis of DFAT accreditation.
All right. Has DFAT advised you that the Palestinian delegation is accredited, the ambassador's credentials have been accepted?
I don't have that information.
Can you provide it on notice?
I can take the question on notice.
I mean, I would have assumed until I spoke with the Palestinian ambassador and his staff that the government recognising Palestine meant that they would have been accredited. Minister, can you explain why the Palestinian ambassador isn't given access to a full diplomatic visa and hasn't had the accreditation necessary to allow Home Affairs to give them the right visa?
I'm obviously not in a position to answer that, but happy to take that on notice.
All right. Can you provide as much detail as you can about what you understand the accreditation to be for the Palestinian delegation? What, if any, communications you've had with DFAT about it?
we will do that on notice, Senator.
All right. And with a particular focus on any communication since the 21st of September 2025, when the government, at least for form's sake, recognised the state of Palestine?
Understood, Senator.
Thank you. I have some questions that sort of drill down into the different classes of visa given in the humanitarian intake. Are you still the best person, Mr. Willard, to deal with this?
Mr. Kiley will join me, I'm sure, Senator.
All right. This is... there have been a variety of NGOs that have been concerned about the reduction in the proportion of the refugee intake that are getting access to, I think it's called subclass 200, which is the, as I understand it, the visa granted for overwhelmingly people who are in UNHCR camps and have been identified by the UNHCR as being eligible for asylum, and they come through the subclass 200 category. Can you explain to me, has there been a policy decision? Why we see year on year the proportion of the refugee program of 20,000 pace, the proportion given to subclass 200 visas decreasing year on year. Why is this?
Thank you, Senator. Mr Andrew Kiley, First Assistant Secretary, Migration, Citizenship and Humanitarian Policy Division. Each year we go through a process with government of setting the composition of the program. That involves working through what proportion of the overall visa places that we have available this year, 20,000, are allocated across the different streams of the humanitarian program. That includes working through the allocation for UNHCR, as you said, how many are allocated to the special humanitarian program, how many go to the community support program, as well as working out how those visas are allocated across different regions in the world as well. As we've discussed in this committee, there's an overwhelming demand for the program at the moment and a number of different priorities that we are looking to give effect to through the humanitarian program, including slowly trying to draw down the on-hand community support program number. So ultimately it's a balancing of different objectives and trying to ensure places are provided for different pathways, but ultimately that's a matter for government in setting the composition each year.
So this is as a result of there being government decisions to grant more onshore visas to the refugee cohort out of that 20,000. More of them are being granted onshore. Is that partly what's explaining this? Is it the fact that the CSP program came in and took it out of the 20,000 as well? What is the reason why we're seeing that reduction?
I can take you through the grants over the last few years if that would assist. There has been a slight increase in the number of onshore protection visas granted in the last couple of years as a result of the investments that government provided to address abuse of the protection visa system.
Can you take me through if you've got the data on the subclass 200 visas over the last 5 years?
Yes.
And what I might ask you to do, if you wouldn't mind, on notice, to go back over 10 years, because some of the data that I've got here references 2016, 2017 as a starting point to get a sense of historical data.
I think I've got...
I know you probably don't.
I might have 10 years data.
All right, if you can.
So this is 25-26 to 31 March grants to date. Subclass 200, 6,960.
6,000?
960, that's year to date.
Yep.
Sorry, March year to date. In 24-25, there were 8,318. In 23-24, there were 7,555. In 22-23, there were 4,773. In 21-22, there were 2,946. It was a smaller program that year, so I can also provide percentages if that would be helpful.
And Senator, in that period that Mr Kiley's been going through, the total number of the program changed, so it increased. So
indeed. So I'm actually realising now, probably what would be useful, Mr Gill, is if you can provide the full set of data, including the program numbers, and then we get a sense of what the proportion is over time.
Yeah, we can do numbers and percentage of grants in the program.
Percentage of grants. I suppose one of the concerns is that organisations have seen a potential reduction in support for UNHCR-backed visas. That's one of the principal concerns. Has there been any direction to reduce the number of visas granted coming from the UNHCR cohort in offshore?
We work closely with UNHCR on a regular basis, both from a program management perspective, as well as we've discussed in this committee, working through the challenges that the program is facing as a whole. We are keen to ensure that, as I mentioned at the start, that we look to address some of the on-hand challenges that we've got in the program and provide pathways for those different components of the program. We've also been working with UNHCR around the process for providing allocations to us, ensuring that we've got a manageable on-hand caseload of UNHCR referrals that will flow through to grants over the coming program years.
Organisations have also pointed out that there's been, more than 200 million cut out of the refugee humanitarian settlement and migrant services budget over the last less than half a decade. And they're linking these two together, that the substantial reduction in support for offshore refugees and the substantial reduction in refugee humanitarian settlement and migrant services budget.
The CFO may be able to assist, but we can take that on notice. I don't think there has been a reduction in funding provided to the humanitarian program over the last couple of years. When it was lifted to
refugee
20,000,
humanitarian settlement and migrant services budget has been radically cut since I think Tony Abbott had it at a substantially higher rate than this government has it at.
Well, over the last couple of years,
substantially high rate.
There was additional funding provided when the program was lifted to 20,000 3 years ago. There was also an additional budget measure a couple of years ago that provided approximately $80 million of additional funding, recognising the increased costs faced by settlement providers.
Probably a convenient time.
Is now a good time to share the call? Thank you, Senator Shoebridge. Senator Dunham.
Thanks, Chair. Just in terms of, and I think some of the questions asked by Senator Whitten before may have gone to this, but unlawful non-citizens, so just so I can understand properly, what makes up that category? Like what types of former visa holders or overstayers are in that category? In broad terms, I mean, it's late.
So at a very high level, Senator, it's people who do not have a valid visa.
Yes, so they've had one and for one reason or another
has expired for some reason or other, and there are various reasons for that condition to be entered into, which I think is the next level to your question.
So the current figure, which we've given before in this committee and is widely reported in the media, is that we estimate that there are 77,700 unlawful non-citizens in Australia.
Yes, I got asked about that on 7:30 report, and I had an old figure and I started arguing about what it was. I was saying it was lower than that. But so 77,000 or thereabouts. Okay. And in terms of, and forgive me again, I can't recall whether Senator Whitten asked this, but in 25-26 to date, how many unlawful citizens have been removed or have departed? Do you keep track of that somehow?
No, Senator, because it is a point-in-time number. So that 77,700 estimate was middle of last year. That number will change dynamically as people leave and as they enter that cohort, as their visa expires or they overstay.
Yeah.
But we can give you numbers, Senator, for example, for how many have been removed over a period.
Yeah, okay. Let's go with that. What sort of a period could we go with, do you think? A 12-month period? How many have been removed in...
Year to date?
I can give you the last
perfect
2 financial years.
Sure, why don't we do that?
So at 31st of March, this financial year, we've removed 2,851 unlawful non-citizens from immigration detention. So after we've detained them. And in the previous financial year it was 3,457.
Okay.
So,
sorry, go on. Just in terms of those people who fall into this category, so I know it's difficult to, and you said it was an estimate, the number of people that make up this number. Do we have any sense of where they are, or we literally lose them? Because with a visa, I assume there is an address, a point of contact.
Senator, if we know where they are, then we do reach out to them, and either seek to detain them or seek to get them onto a short-term visa to facilitate their departure from Australia. We don't kind of keep a running track of unlawful non-citizens and then not do anything about it.
Yeah. So then of the 77,000, they've just...
So it's an
visas
estimated
expired?
figure based on us tracking how many people have arrived in Australia, how many people have departed, how many visa holders there are, and we also take into account when we know someone has died or deaths as well.
Sure. And so with deaths, like you're notified and it comes up on a system somewhere, so you get that data.
Yeah, there's a reporting of a fact of death.
Yes.
That when that's reported, then that changes the person's status in the system and that'll be reflected. There is an issue in terms of fact of death data sets and matching that with visa holders. But essentially, yes, we get a fact of death report. That'll result in the person being marked as deceased.
Okay, but that estimate does represent a group of people that have visas have expired and they are here unlawfully and we don't know where they are, broadly speaking.
Broadly speaking.
Yes, I mean there are some I'm sure that you're close to detaining or maybe on the way to. What do you have any data around how long some people have been in this category for? Like, are there some extremely long-term?
Not in front of me, Senator, but it will be, as I've said previously, a range of people numbering days to weeks to months to years. It's quite a varied cohort, but I don't have specific breakdowns of data in front of me.
Does the department retain that sort of data?
I could take that on notice, Senator. To give you a
Sure,
sense.
yeah, if you could. Does the department have a target around trying to bring that number down? I mean, I know you wouldn't just arbitrarily say, well, let's take 5,000 out every year or whatever, but is there some sort of band you want to get to?
We don't have a fixed target written into our corporate plan. I gave a similar answer in relation to the number of removals, which is because these are people. There are some that are easier. Like basically, our top focus area is where someone's unlawful and they've committed a crime. They get our top priority. So. The vast majority of our resourcing goes to if we have a police report, somebody has been remanded, for example, police will give us a ring, we will pick them up and deal with their case as a top priority.
Got you.
we don't set a target on a number so much as trying to ensure that those top priority cases are dealt with quickly.
Jacinta, I mean, ideally, you were saying to me before when I said it was a relatively small number of visas that we had to cancel because we found new information. Ideally, we would have no unlawful non-citizens in Australia. We would have everyone on a visa or removed. And we have a very strong philosophical position that once people's visas expire, they have no right to be here and they should not be here. What I'm finding is that this number is relatively sticky and has been not dissimilar for many years. And there are a range of reasons for that. And we are always looking at, are there different approaches we can take to this cohort which will get us a better outcome? But it is a pretty challenging problem.
Okay. In terms of, so every time someone is remanded who might be in this cohort, that is an automatic, like you are then able to deal with them in the way you wish, which is to remove them from Australia.
So, well, the first step, Senator, would be that the police will contact our team and do a visa check. If that visa check reveals that the person does not have one, then we will work with them to work out what the police are going to do next, and if the police's intention is to release them, then we can work with them to have our ABF field officers there available to detain them and take them into immigration detention.
Okay. Just back to some questions aligned to the ART matters we were traversing before. Do we know how many non-citizens with criminal convictions have had visa cancellations set aside by the ART in the last 12 months?
No, Senator. I'd have to take that on notice to see if that's a number we'd have to look at every ART case to determine if there was a level of criminality. But for those character ones that I gave the numbers for,
okay,
you can assume that the cancellation refusal or revocation refusal was because of criminality.
Yeah,
So
okay, all right. Yeah, don't
or
worry
a
about
character
that.
issue,
I don't want to cause the Minister to have conniptions about questions on notice for next time. That's fine.
Thank you.
Look, I've got nothing more, Chair.
Thank you very much for your assistance. Senator Shoebridge.
Thank you, Chair. I'm just trying to get an understanding of the budget commitment to support migrant workers. There was $27 million over 2 years from 26-27 to continue information and education activities to improve migrant workers' awareness, awareness of workplace safeguards, protections and compliance measures. Where is that funding going, the $27 million?
Senator, this is a program that was started, I think, 2 years ago. It was a grant program that we ran, and the grants were largely awarded to unions, recognising their kind of access to workplaces and ability to effectively reach the target cohort. This new budget measure will be awarded through a grant process as well.
And is it going to be an open tender process? What's the nature of the...
We're in the grant design phase at the moment, and grant guidelines haven't yet been approved.
Is it going to include, for example, getting geographical coverage? We know in places like the Riverina in New South Wales and Victoria, there's been a lack of legal services and support services in that region. Is it going to look to those issues?
Certainly that's the aim, is I wouldn't commit that we'll get every area in Australia, but we will be looking at the areas that have the highest risk.
All right.
In terms of needing the coverage the most.
Is it also going to look at those parts of the migrant worker community here which are most open to exploitation? For example, the Migrant Justice Institute in its recent report and research found that about a third of all migrants who they surveyed, 36%, but over a third, were paid below the national minimum wage. Have you had a look at that research from the Migrant Justice Institute?
I have read that paper.
And is the $27 million going to respond to the data coming out of the Migrant Justice Institute? And, another area obviously to consider is fast food, because I think they found 90% of workers in the fast food industry have experienced wage theft.
Senator, I think it's fair to say there's a really strong focus from Minister Burke and the government on what we are doing to better support migrant workers. I think there's lots of discussion in the budget about it being a responsible budget. This is one area where funding did increase due to the interest in really focusing in on doing more to do what we can to give better information to workers. It's being accompanied by a prioritisation in our field effort as well to go out and identify and crack down on employers who are doing the wrong thing.
And it builds, Senator, on a range of reforms over the last 2 or 3 years, including legislative reform, different visa types to help protection. So the figures you're looking at in this budget are part of a program where we've been seriously trying to tackle this problem of worker exploitation through a range of legislative, regulatory support compliance activities?
Not at this estimates, but we will look at some of the concerns that people have about the pathways into I think it's called the Workplace Justice Visa,
Yes.
and some of the concerns people have about timeframes. I'm sure you're aware of them.
Yep.
Yes,
the narrow
Senator.
timeframes in which people can. Is there a review of the
There
Workplace
is.
Justice Visa?
We're currently mid-evaluation of that. So we would, the next estimate, so that evaluation is due to report into us in September. So we should be able to talk about those results.
And
All right.
Senator, obviously any information that can be provided to us to help with that review would be enormously helpful.
I will share this exchange with those many NGOs and others who are concerned. What about some of the money apparently is about strengthening systems capability. There's been some other budget in that space. Is any of that going to go to crunching the data and looking at and ensuring the data is captured and then brought forward when you've got businesses looking to sponsor migrant workers, but they've got a history of workplace non-compliance or the like? What's happening in that space to ensure that some of these bad employers don't keep getting access to vulnerable workers?
I will need to take on notice whether the budget measure that has the systems capability money, whether any of that can be deployed for that particular problem. But we are, as I said, very much focused in on this issue of with the recent passage of the sponsor and nomination legislation as well. How do we best implement a system that we've found measured? We can kind of talk individually, measure by measure, but
Well, even a national database, we would like to get that legislation through so people can see.
We're also monitoring, Senator, the compliance activities that our field operations team is undertaking, the number of fines and infraction notices that we're issuing, so that we are seeing a real ramp up in that level of activity.
But are you then
targeting
creating the
employers.
database so that if that's from an employer where perhaps a series of directors or a couple of key directors then go and phoenix a company, are you able to track them through when they phoenix and, come up with Riverina orange picking 1, 2, 3?
why don't we take your question on notice so that we can give you a pretty detailed answer on how the alerts work.
I'm always anxious when things get taken on notice in
I
this
know.
committee, but yes, you can take it on notice.
So, Senator, I think what we're trying to do is make sure that we are looking at
Do you
the
know,
whole
Ms Foster,
system.
I'm not complaining about this being taken on notice
Okay.
if I get a more thorough answer in a timely fashion. So, yes. Could I ask about student visa holders? I mean, when you look at some of the data about theft, particularly in the fast food industry, rideshare, delivery, etc., we know that a big chunk of that workforce are actually people on student visas. They're studying here, but of course they often need to work in order to live and pay for some essential costs. But to be honest, if you want to try and get some accommodation in Sydney and buy a meal in Sydney, go shopping in Sydney, if you're trying to live on 24 hours of work a week, that can be next to impossible, and that cap is driving people into insecure employment because that can be the only space they can find employment. Are you looking at that, potentially raising the cap for students?
So, Senator, there are different equities we're trying to balance here, and as you know, part of the reason for the cap is to ensure that students are actually studying in Australia.
Correct.
And so the level at which that limit is set is trying to balance the equities that you're talking about and those around
But of
being
course-
genuine students.
I mean, how does it work for student visas when they have a 1-month study break, or they have a 1-month, they have 2 months off over Christmas and New Year?
Senator, I think we're getting an expert to the table, but
Yeah.
I understand that actually during breaks the hours change.
Is that?
Nothing for me to add. 48 hours a fortnight during term, and in breaks it's unlimited work.
All right, good. But can I tell you the information we're getting, including from unions, and especially in the fast food and delivery space, is the 24-hour cap is seeing students significantly exploited because they feel like they can't complain about underpayments, they can't complain about their treatment, they can't put a claim in if they're injured if they've gone beyond the 24-hour-a-week working cap. It's a real matter of equity. I know you talk about balancing equities, but where is, is there a consideration of even lifting it to 30 hours a week?
Senator, there is not at the moment.
All right. To stay in the sort of vulnerable worker place, the Modern Slavery Commissioner, the New South Wales Anti-Slavery Commissioner has identified the PALM scheme as being a modern slavery risk, as has the UN Special Rapporteur on Contemporary Forms of Slavery. That's a pretty harsh finding about the PALM scheme. And, it's coming from within Australia with the New South Wales Anti-Slavery Commissioner. What's your response to those findings by both the New South Wales Anti-Slavery Commissioner and the UN Special Rapporteur?
I think those questions are probably better put to the lead agency, which is the Department of Employment and Workplace Relations.
Well, I'm more than happy to go to them, but of course the PALM scheme, Home Affairs has a significant role in regulating and granting visas under the PALM scheme. So I'm asking the question of this agency.
Senator, the Department of Employment and Workplace Relations manage the design of the scheme. They manage the workplace, workplace justice type issues, employers. They really are much better placed than us to take questions.
Well, but you assess employers and you grant the visas, is my understanding. That happens in Home Affairs, correct?
Yes,
All right.
Yes.
So then, for example, the most recent data we've got that's been published for the scheme shows that in 2022, out of $990 million paid in for the purposes of, the PALM scheme and PALM workers, 30% goes to the employer for costs and add-ons, 15% goes to the Australian government in tax, 18% is remitted, and 21% is spent by the workers who are here. How is it that 30% is going to the employer, often for costs like food, accommodation, clothing? How is that happening?
Senator Shoebridge, we're really not trying to be difficult, but these are very good questions to put to DUA when they appear next week. What I can say is that under this government, significant improvements have been made to the PALM scheme to reduce the exploitation of workers. The DUA can talk in detail about those changes, but we've always acknowledged that there is always more to do to continue improving the system.
All right. But does Home Affairs, when they're assessing employers for the purposes of the PALM scheme, do you look at some of that data to see if they're a credible employer, such as how much of the workers' wage they're taking and how much they've done historically?
DUA does that work of effectively vetting the employers.
Does
not
Home Affairs?
I don't think so.
Do we have some more information on what Home Affairs' role is? I'm assuming you're not just getting your steps up.
Maybe,
Ms.
Senator.
Goodchild? No.
So the Minister's correct. In terms of who determines who is an approved employer for the PALM scheme, that is done by the Department of Employment and Workplace. So in terms of us, we just make the visa determination on the PALM applicant.
All right. Can you explain how the number of PALM visa holders employed in healthcare and social assistance has so substantially increased? The numbers I have show it as a 500% increase between 22 and 24, with about 1,200 people under the PALM scheme working in that sector. When it was my understanding, it's the public sales pitch on PALM, it's for unskilled work? How is so much of it happening in the healthcare?
There's been a
social
conscious
system?
decision by government to use the PALM scheme for work in the care sector, partly to fill, workforce shortages in that sector in Australia, partly for the benefits to those workers in the Pacific in providing upskilling opportunities in those sectors. Like, I know a little bit about this, having been the Agriculture Minister. It's obviously a big scheme in the agriculture sector. You would be aware, Senator Shoebridge, I'm sure, that the benefits of the Pacific are not only the remittances that are sent back to the Pacific by these workers, but the opportunity for upskilling in a range of sectors like the care sector.
No, but the other elements of the PALM scheme, the essentially temporary part of it, the very limited horizons, they don't sit well within the traditional migration intake in the healthcare sector into the care sector. That's the issue. That when we bring people in for those kinds of jobs, skilled jobs, we've normally given them a genuine horizon here, not a short-term PALM scheme.
Well, again, these are one issue this department might be able to talk to you about, given it's, I think, in their responsibility, is it Pacific Engagement visas? There have been certain visa categories that have been created by this government to provide essentially pathways to permanency. So that is something this department could talk about.
But this isn't 1,200 people from Tuvalu. This is 1,200 people in the PALM scheme. But if you've got, you can shed some light on it.
Senator, so the Tuvalu stream's actually separate. So the
yes, I know that's what I'm saying. Yep.
No. But PEV, which the minister referred to, is actually a different scheme from Tuvalu. Also, it provides up to 3,000 permanent visas.
But that's not part of the PALM scheme. That's separate to the PALM scheme.
No, but it does provide a permanent migration pathway.
Yep. Which I have no issue with in terms of rolling it out for healthcare and allied services. My question is about the fact that PALM scheme is now being used for that, when almost uniformly that kind of skilled migration has a pathway to permanency.
The PALM scheme, the elements you're referring to, Senator, which is also a question for DEWA, but it is for lower skilled workforces like aged care assistants, childcare workers, that they have expanded that out to, and they're offering opportunities for them to get skilled in that by giving them certificates and that.
Well, I challenge the concept that childcare and aged care are inherently low skill work. In fact, especially, I would challenge that as a concept.
I think, to be fair to the official, Senator Shoebridge,
Ms. Goodchild's trying to help. I'm not.
I know. But honestly, many of the questions you've got are absolutely warranted, but this department does not have the knowledge of some of the issues that you're looking.
But can you give me, if you have the data, the breakdown for the PALM scheme going back since probably fairly since 2021, breakdown by category of employment, if you have them, which will show.
Is that something this department has, or again, is that a DEWA?
Why don't we take it on notice and we'll see what we can do working. I think that it will require us to work in partnership with DEWA.
I'll take you up on your suggestion with DEWA next week as well. But I know that the Chair, you wanted to rotate.
Thank you for your assistance, Senator Shoebridge. Senator Duniam.
Thank you. I thought I was done. I just have a quick question. Couple of questions. In an interview on the 22nd of April this year, Minister Burke told SBS News, and I quote, "I've never accepted the word assimilation. I don't want people to lose who they are. The word integration is one that's been used as part of a multicultural dialogue for a very long time, and that's what it is. Like, we want people for who they are. I've never subscribed to that sort of melting pot concept that your whole identity is meant to be dissolved." So that being said, just in terms of the department's approach to immigration policy and multicultural policy, is it the department's view that assimilation is not an appropriate objective to have as part of the work that you do?
Senator, I think we're getting really close to asking us for an opinion. Our role is to implement government policy.
Yes.
Obviously, we provide advice and we input to that. but our opinions about what is good for multiculturalism, I don't think are.
I thought you might say that, you know. I did think you'd say exactly that. Would you believe, in another conversation? So I might ask you then, Minister, and
Sure.
we'll keep it brief. So on the Minister's behalf, can you define the practical difference between integration and assimilation as it relates to the government's current handling of the migration program?
Well, I'm not sure it's wise for me to interpret and explain the comments of a different minister.
Okay, all right. Thanks, Chair.
Thank you, Senator Dunning. Senator Shoebridge.
Yeah.
By the
I'll
way,
explain another time.
it'll be Wednesday next week in terms of the due estimates. It falls under the employment part of that department.
All right, thank you. Whilst we're talking about what falls in and what falls out, we did seek some advice earlier about the foreign fighters, you know, or people fighting him, and we were told it was outcome 1, and we had been relying upon that. We now know it's deal with it in outcome 3, but we had it in writing. Just for clarity, we have asked about questions relating to the deal with Nauru for regional processing of NZYQ, not the cohort in Australia, but the offshore aspect. We were told that is outcome 3 and we're operating on that basis. But I don't want any surprises tomorrow morning. We have it in writing, but writing wasn't working earlier this morning.
Are you sure? Don't we normally do regional processing in 3? Check with Michael.
We
I believe
literally
you're
have
right.
that in
Ms.
writing.
Sharp is challenging me, and we're just checking.
Yeah. Yeah. So our understanding, Minister, but noting it's late, is that regional processing, that is the arrangement that's been in place for many years, is dealt with in outcome 2. The arrangement with Nauru under the third country reception arrangement for the management of the NZYQ cohort is dealt with in outcome 3.
All right. That's what I'm asking about. NZYQ cohort is outcome 3.
Correct.
Yes, all right, good. I have some questions about contracting for passenger air transportation. I'm told that's outcome 2, yes?
I'm sorry, Senator?
What was the...
Home Affairs contracting for passenger air transportation and for other air transport contracts.
Like assisted passage for our humanitarian intake?
Well, amongst other things, the subcontracting arrangements that you have that ultimately end up with Nauru Air and your other subcontracting arrangements for other air charters.
Yeah, I think that's outcome 3. That's to do with removals.
Well, they're not all about removals. Maybe I'll ask the questions then if they can be answered here, but if they are appropriate to be answered tomorrow, I'm happy to have them answered tomorrow. Department signed a $104 million contract with Addergold Aviation for passenger air transportation. Was that subject to an open tender? If so, how many responses were received to the tender? And what exactly is the government, the Australian taxpayers, getting for that $104 million with Addergold Aviation?
We're just checking whether that's a Border Force question or ours. It's Border Force, so it is outcome 3.
All right. There's a contract with SkyTrader for so-called mail and cargo transport at a cost of $191 million. Again, was that subject to an open tender? If so, how many people responded to it?
Again, I believe that's outcome 3, but we
All right.
will...
I have questions generally about the air charter spend by Home Affairs, 85% of which has gone to just a handful of corporations. This outcome 3. I'm going to...
Senator, we use charters for a range of different circumstances, including removals.
But the Addergold Aviation contract is outcome 3?
I believe so, Senator, yes.
The Sky Trader contract, outcome 3, or?
I'm not sure, Senator.
It's $191 million. And I think there's been 300...
The advice I'm getting is that these are all outcome 3.
Outcome 3s. Okay, I'll take them to outcome 3. To return to a different aspect of Palestine, Palestinians with valid visas, if they come to Australia from Gaza, or more broadly from Palestine indeed, need to do so in coordination with this Israeli agency called the Israeli Ministry of Defence Coordination of Government Activities in the Territories. I think it's called COGAT, C-O-G-A-T, that's how it's often referred to. Israel has said that COGAT is effectively the sole way in which people in occupied Palestine can access and get access to exit the country. And Israel has said, and I quote, "We invite the third country exit mechanism is not only for patients and their companions, but also for visa holders and dual nationalities. We invite you to direct this matter to the embassies of different countries so that each concerned embassy can transmit their withdrawal request to us for approval." So it's essential, if Palestinians with Australian visas are to find their way here, they have to go through COGAT, and therefore Australia needs to have a relationship with COGAT. We have been told by multiple people that Australia refuses to have a relationship with COGAT, and there is no relationship with COGAT, and so the people in Palestine are stuck in this catch-22 situation. What is the situation?
Senator, I have some familiarity with COGAT as an entity. I don't have any engagement with them. I think you would need to talk to the Department of Foreign Affairs. I'm not aware of the current status in terms of the Israeli processes.
It may well be that COGAT is a particularly awful agency with a bad history, but if that is the only way that people in Palestine with a visa to come to Australia can access Australia, can come to Australia, if Australian authorities have a relationship with COGAT, that is essential. Is it your understanding that that relationship would be mediated through DFAT, or would it be mediated through Home Affairs?
There's not a relationship with Home Affairs and COGAT. I'm not aware of whether DFAT has one.
Well, that might be the problem, because there's apparently no relationship between any Australian authority and COGAT. And that means that people in Palestine with valid visas can't get to Australia.
I mean, Senator, from our perspective, the visa provides for entry to Australia. It doesn't provide for exit from any other particular country or entry to another particular country.
But Israel apparently is putting this additional requirement for countries where people in Palestine have valid visas to visit, for them to transmit their withdrawal requests through COGAT. And the absence of any kind of connection between Australia and this entity means that people in Palestine cannot get out.
Senator, I think what Mr Willard's saying is that our role is the provision of the visa, and he is unaware of the relationship that DFAT has, but we can take on notice this question to the extent it falls within our responsibility.
Yes, and to be honest, I don't know if it would normally be something that falls within Home Affairs, a Home Affairs officer in Tel Aviv or Ramallah, or it would fall within the remit of DFAT, which is why I'm raising it with you here. Could you take it on notice to see what, if any, knowledge you have about COGAT, what, if any, approaches have been made, and what the response will be?
Absolutely, Senator.
Thank you. Can I ask some questions about family visas? And near the end, you'll be pleased to know. In the budget, the government made clear that there's a prioritisation of skilled migration. But then when you look at the backlog of family visas, people wanting to reunite with parents or partners, that makes up the overwhelming majority of the backlog. You know, when we look at the numbers from 25-26, the most recent data we had was 157,000 parents are waiting in the backlog and 97,000 partners are waiting. And these are all-time highs as I read them. What's going to be the impact of further prioritising skilled and therefore, by necessity, deprioritising parents and partners?
Senator, the composition of the program and the skill family split is one that's a decision of government. My understanding is that we are maintaining a 70-30 split between skilled and family for 26-27. It was 70-30 in the current financial year that we're in.
Yes. What do you understand that will mean for the backlog for parents, and what do you expect, what are your predictions that will mean for the backlog for partners? I mean, they're at all-time highs now. You must have had a look and be predicting what the numbers will be going forward. What's your prediction?
Senator, I think in terms of parents, it is a very difficult decision for government to allocate places in the parent program. It is very much, there is huge demand for parent visas. You've mentioned some of the numbers. We try and make very clear what that translates to around potential wait times so that people are aware of that when they're looking for to make an application. We would expect that applications will exceed the number of places available in the parent program as it has for many years. In the partner program, it's a similar allocation to previous years, so we would expect that we might see that on-hand number grow slightly over the year ahead. It will depend on application volumes.
Well, I mean, there's a lot of discussion about, you know, social cohesion and a migration system that is designed to, you know, create social cohesion. But if we've got a migration program that, you know, is skewed towards bringing 25 to 35-year-old men into the country without allowing partners and parents and family completion, you're not creating the environment for a flourishing and successful migration program. You're creating loneliness and distance and a lack of intergenerational connection. And that's what these numbers are showing, isn't it? People can't get their parents here, they can't get their spouse here, their partner here. It's the exact opposite of what a well-rounded migration program would produce.
Senator, I think that's why I began my answer before by saying these are really fine judgments about how the composition of the program. They're a matter for government about, there's so many different equities that are being balanced, both economic, social, as you've alluded to, the demands of the economy is critical. I would just point out in relation to partner that there is also temp partner pathways that are available that can be used to support reunion while someone might be waiting for a permanent place.
Can you also explain the wait times, say for a parent visa? We're told that somebody from the US tends to wait a few months for a parent visa and has them rapidly processed, but wait times are very different if someone's coming from Iran or they're coming from Thailand, Sudan, like incredibly distant. How does that work in practice?
The permanent parent program it goes through a queuing system, and so people are assessed and allocated a queue date. The reason for that is because of the oversubscription in terms of available places. There's a very strict queue date that's applied, and then application, and that's when someone's determined to be likely to meet all of the requirements for the visa. When they're queued, there's a very strict processing order of according to the queue date.
So is the difference nation by nation on the basis of when Home Affairs determines they're likely to meet all the conditions? Is that where would that explain the significant discrepancies we're hearing for timing?
I I don't think there are significant discrepancies. I think all of the parent visas have long wait times. There are two categories of parent visas. One is contributory parent and one is just parent. Contributory parents, whatever nationality they might be, do have slightly shorter processing times, but that's in the program design.
Can you provide on notice what the current wait times are for each of those classes of parent visas?
Sure.
And perhaps if you could go back like 5 years so as we get a sense of where that's going. But, you know, we're talking for some of these over a decade, aren't we?
Yeah, I have some figures here. Contributory parent is looking at about 15 years. Parent is looking at about 33 years. That's the extent of the on-hand applications.
And can you provide me on notice how many parents died while waiting in those queues in this financial year and last financial year?
I will take that on notice.
Yep. And just quickly, Ukrainian parent visas. Because of how those, there were changes announced, there were new visa classes announced as developments happened in Ukraine. I understand that there are over 100 applicants who have found themselves kind of sort of left a bit high and dry. Maybe I can explain it. The offer of a resolution status, was it an 851 visa?
Yes.
For Ukrainians? It was made in October 2024, but by the time that offer was made, there'd been so much water under the bridge between the commencement of hostilities in 2022, the Russian invasion, that a whole series of families transitioned to other visas, and they were primarily parent visas. I think they're subclass 804, 103 and 143. Now, those who, and it was often as a result of government advice, you should apply for another visa, you should apply for another substantive visa, your tourism visa, your whatever their temporary visa was expiring. Those who followed the advice and got parent visas are now subject to exclusions from a whole lot of access to benefits, Centrelink benefits, Medicare, etc., because they don't meet the, is it the qualifying residence exemption? Yet those who didn't follow government advice and just waited and then got the resolution of status visa had effectively immediate access to those benefits, which was a good thing about the resolution of status visa. Now, I'm told the numbers show there's about 105 applicants who chose that parental visa option following government advice and are now finding themselves excluded from benefits. But if they just waited, they would have had access to the resolution visa and had access to the benefits. That seems unfair to me. Are you aware of that issue?
I'm not aware of that issue, Senator. You mentioned it was 105 people on parent visas from Ukraine.
Yes, 105 were, that's my understanding. Okay. So I don't know if they're all on parent visas, but they're all subject to visas that exclude them from access to Centrelink benefits and Medicare visas. So, as you know, I think many of them were on was it a 786 visa? Mm-hmm. And they transitioned to other visas before the introduction of the 851 visa. So we're talking about that category. Could you check the numbers of those who transitioned from a 786 visa to other visas before subclass 851 was open? Yeah. And can you provide the numbers of those who are, because they've done that, have been excluded from benefits available for the 851 visa?
I can take that on notice, Senator. Can I just define it so it's clear? You're talking about Ukrainians who were in Australia,
correct,
who transferred to another permanent visa
before the availability of 851 was found. Okay. Yes.
Yeah, I can take on
and
notice.
And then when you have a look at the numbers, could I ask if there's any plans for some kind of equity to be available here? Maybe there could be a short period where the 851 visa is open to those. They could transition to the 851 visa because it does seem a structural unfairness to some of those, particularly Ukrainian parents.
I could take it on notice, Senator, just to understand that cohort first.
All right, thank you. My very last questions are about the Afghan refugee visa processing. The government, and it was partly under the former Morrison government. I don't give much credit to the former Morrison government, but their actions for the Lee program, I think, were admirable. Apparently, the Lee program is considered one of the highest priorities for the government, given the risk that those partners in Afghanistan put themselves in assisting Australian personnel. Can you provide an update on the number of current applicants on hand?
Senator, Mr. Kiley, I have some figures. I would make the point, since the fall of Kabul, the department's granted 33,483 visas to Afghan nationals under the offshore humanitarian program, but you're asking about the LE program in particular?
I am, yeah.
So I've got data going back back to 2012-13. I might just do the last couple of years, Senator. So in 24-25, there were 111 certified LEE applications granted, covering then 1,086 individuals, if you include family members.
Yep.
25-26 year to date, as at 31 March, 440 primary applications granted, covering 2,506 individuals. And we currently have on hand 375 applications remaining, covering approximately 2,100 individuals.
So that's the total number on hand, 375?
375, that's right.
Okay. Is it predicted that those will be processed this year, the 375?
As you said earlier, they're the highest priority, Senator.
Okay.
So I would expect we get through a few more this program year, but I expect most will move into the next program year.
Can you remind me whether they come from they come out of the places that were allocated for Afghan refugees?
Yes.
Yeah. Now that allocation finishes in July, doesn't it?
Yes, this is the last program year where we had the
What
4,000.
impact is that going to have on the Lee cohort?
So going back to the earlier line of questioning, Senator, we'll work with government to set the composition for the 26-27 program year. That program is still set at 20,000. I would expect that there would be a reasonable allocation within that to Afghans again, but that would ultimately be a matter for ministers to determine.
Is there any proposal to prioritise applications who are related, applicants who are related to a Lee certified person? Because once somebody's been identified as Lee certified, I'm told that their extended family can be at risk in Afghanistan.
There's no specific priority provided to those. SHP provides some priority for immediate family members, but not specifically to family members of LEE.
Do you know what the, moving beyond LEE, what the current number of Afghan applicants waiting for asylum claims is? It was last time, September 2025 was, I think there were 140,000 Afghan applicants. How many are there now?
Yeah, so 36,573 on-hand applications, covering 136,410 individuals, again at 31 March this year.
That's at 31 March. A tiny reduction from September, but still a massive backlog. What is the government's plan to address that? Even if it's in communications, what is the plan for the 136,000 people?
So there'd be a couple of elements to that, Minister. The first ultimately is what allocation government provides within next year and future year programs as to the number of places that are provided to Afghan nationals. As has been the case for a couple of years, the vast majority of those will likely be processed and refused, given there are only so many places available in the program. And then if there's any further decisions made by government, that will be for government.
All right. And finally, I understand there are about 50,000 of the Afghan applicants are actually in Iran at the moment. There's a freeze on processing biometrics. I understood there was a general pause on processing any claims that are coming out of Iran. What's the status?
there continues to be limited ability to process visas out of Iran. We do what we can. Your number's about right. I have 54,000 individuals in Iran. But you are right, the situation on the ground in Iran makes it very challenging.
How many
to
have been
process visas.
processed since the outbreak of war?
How many have been processed? I don't have a breakdown of how many have been processed out of, like how many individuals in Iran have been processed in that time period. I can
you
take that
provide
on notice.
that on notice?
If we have that breakdown, yes.
All right. Thanks, Chair. I'll put the rest on notice to be...
Yeah, and we look forward to Minister Watt speaking about those in cross-portfolio.
I remind you, we finished early to put some on notice.
I don't object to any of the questions that have been put on notice today. It's the silly ones we get when we leave the room.
Well, that does conclude today's proceeding. I thank ministers and witnesses for their attendance, as well as Hansard Broadcasting and the Secretariat for their assistance. And I do thank my committee members and fellow travellers today for their assistance in finishing ahead of time. I don't think we've tabled anything today that needs to be tabled, so I'll move past that and remind senators that written questions or notice should be lodged with the Secretariat by 5 p.m. Friday, 5th of June. Hearing is adjourned.
Thank you.